Good morning, all. I welcome you all to the today's program workshop on arbitration. Uh, okay. Um, so we are honored to have our distinguished chief guest, Mr. Veeraraghavan Inbavijayan sir, among us. I request him to occupy this chair, sir. Before the program, I request the members to rise up for the ICI motto song.
येष सुप्तेषु जागृति येष सुप्तेषु जागृति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तदेव शुक्रदब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्वैता 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 एतद्वैता.
Thank you. So, before the start, I'd like to have a short introduction about our chief guest, Advocate Veeraraghavan Inbavijayan sir. He is an international arbitrator, mediator, and advocate, and has over 2 decades of experience in arbitration. He has presided as sole arbitrator and represented as counsel in over 400 domestic cases, several small-scale commercial financial arbitrations, and 17 international arbitrations. His areas of practice include international commercial arbitration, maritime arbitration, international trade and contracts, IPR, construction disputes, finance and banking disputes, security markets, joint venture, letter of credit, alternate dispute resolution, sale of goods, domain name disputes, and investment disputes. He has been accredited as an arbitrator in Hong Kong International Arbitration Center, China International Economic and Trade Arbitration Commission, Asian International Arbitration Center, Dubai International Arbitration Center, Saudi Center for Commercial Arbitration, and International Council for Commercial Arbitration, and various other regional and national arbitration institutions, including various ODR platforms. He is also the project advisor for Arbitration Institution KFCRI. In addition to his practice, he is also promoting the concept of ADR by way of writing articles and books, providing training courses, and give lectures on arbitration and ADR in law schools, universities, chambers of commerce, and conferences worldwide. On behalf of SIRC of ICI, I truly welcome our chief guest today, Advocate Veeraraghavan Inbavijayan, to the today's section. I also request CA Uttam Chand sir to honor our chief guest by giving a memento. Thank you, sir. Without further ado, I request our chief guest, Advocate Inbavijayan Veeraraghavan sir, to continue the session and share his insights on this topic.
Good morning, one and all. Yeah, it is an interesting session what has been given to me today to address about a recent development about arbitration, particularly the law. Most of you being chartered accountants, all would be interested to just find a value addition to our whatever we have been trained for. This particular subject, when it comes to understanding the law as well as the process, we all have to get back to the basics first of all. What is the basic here? Many of you would have heard or come across the acronym ADR. I heard about the acronym ADR. Obviously, it has to be addressed as alternative dispute resolution. But of late, when you just look into this ADR, it is not going to be an alternative. It is an appropriate dispute resolution. It is an accepted dispute resolution. It is an authenticated dispute resolution, as well as it is authorized dispute resolution. I'll try to explain why so much of understanding of this particular acronym to be. To take up an illustration, many of us would be familiar with the acronym ATM. What does ATM mean? Yeah, if it's quite technical, we'll try to say it's automated teller machine. As a soft comment, what might be ATM? Anytime money. Further, all time money. We have multiple options to understand when it comes to the acronym ATM. But if you just ask a kid about ATM, what would be the answer? Kid. Nowadays the kid means it is what you can say less than 10 years old. As parents, we will try to just make them understand the alphabet A to be apple to a kid. Anyway, it will take some time for them to understand it is to be AI. But they keep on saying that you have to just consume apple so that you will be healthy. And the next letter T, what would be the answer from the kid? It's a very delicious one, but obviously it's not good for us. At least if you are 30 plus, it's not good for our health. What would be T? Any guess? Pardon? Toffee, to some extent, is good only. That's what I mentioned. 30 plus, it's not good. Everyone would like to have it. No? No? It's very simple. It is tamarind. Kid, when they go to the hometown or the rural place, they'll just try to climb the tree and plug it off. And it's a delicious one. Even now it is delicious. But the worst part is not good for health. But still, if you ask the child, A is apple, T is tamarind. What might be M? Yes. As a kid, when you are going to understand ATM, it is nothing but apple, tamarind, mango. As well as when it comes to ADR, as chartered accountants, your understanding initially should be American depository receipts. Nothing beyond that. If you are just trying to go to understand this to be an alternative dispute resolution, it is quite vulnerable initially. But here, what role you are going to take is very important to understand this particular acronym ADR. Whether you are going to act as consultant, whether you are going to act as a representative of the parties in an arbitration process, whether you are going to act as experts, financial experts in arbitration process, or whether you are going to act as arbitrators. There are 4 roles. And considering these 4 roles, when you are looking into this particular acronym ADR, you should not treat that to be an alternative dispute resolution. You have to treat that now to be only the appropriate dispute resolution. 20 years back, it was just an option, but now it has become mandatory. Each and every contract which you are coming across would have an arbitration clause, whether you like it or not. When I started getting involved in arbitration some 20 years back, I used to see the partnership deed drafted by chartered accountants having a one-line arbitration clause. If any dispute comes, dispute would be resolved by arbitration under 1940 Act. I started looking into in 1999, it was 1940 Act. The 96 Act also was brought in. But it's a very common one, and it was a regular practice to see this clause predominantly in partnership deed. And later it just moved to development agreements, construction agreements. And now it has become that the government, when they are entering into any commercial contracts or procurement contracts, whatever contracts, they are incorporating arbitration clauses. That means when you are going to deal in any of these roles except arbitrator, when you are going to consult, when you are going to be expert, when you are going to represent them in any forum, you have to end up only in arbitration. That is the unwritten rule at the present scenario. We have to consider this area to be accepted. Why? Because now the parties have started agreeing in their contract to arbitrate. The structure of the arbitration clause might be different, but if the parties are inclined to arbitrate in our country, the hidden or the default rule is that we have to follow the arbitration law, what is prevailing. It might be going to the basics like going to your CA courses, but it is very, very important when you are getting involved in arbitration because the parties have accepted for it. You might have prompted, you might have provoked, but still ultimately they have accepted for it. That means this process can happen only with mutual consent. It is not an offer by one party, it is going to be an acceptance also. If two parties bilaterally they agree, the conditions might be unilateral, but if there is bilateral agreement, then only we can just go. In that way it is accepted. It is not only accepted, it is also authorized because of the law, what we have. The perspective of understanding arbitration to be a normal negotiation or an advanced level of panchayat is gone. The law is structured in a manner that it is universally accepted and it is also applicable in the way the judiciary also appreciate it. It's very, very important. It's involvement of all the stakeholders, making it constructive and realistic. And finally it is being authenticated because the outcome of that particular process, that is normally we used to say judgments, decisions, outcome, sentence. In arbitration alone, the term used for the outcome is award. Normally award, when I think in the morning just 5 minutes before they gave me an award, it doesn't mean that award which I have gained. It is just an entitlement. What I am entitled out of the contract. That is the very objective of the term award included in the arbitration process for the outcome. Now, to what extent it can be executed or enforced? Everyone have understood the 1940 Arbitration Act to just recognize this arbitration, and ultimately when it comes to the award has to be ratified or registered or authenticated by the court, then only it can be enforced or executed. The development in law has now made it authenticated because once an award is given by a private individual or group of individual, after a certain time period like 3 months plus 90 days, it is enforceable as well as executable. Well settled principle. Because of all these, now it has become appropriate with the acceptance, authorized and authenticated. This has to be in our mind when you're just moving forward understanding this particular law. Okay. This is just a gesture of my presentation, and for all of us to understand, this is the law behind the arbitration process in our country. We do have a history. It is quite early, 1889, when the Bengal regulations was brought in, the arbitration was legalized. And in the 1940, the British India, including Pakistan, Myanmar, all these countries, Bangladesh, we had Arbitration Act 1940, which was wonderful legislation, but it had to accept multiple treaties, conventions, and they wanted minimal court intervention. Because of all these, this particular act came into existence, the Arbitration Conciliation Act 1996, which is even now considered to be the principal act dealing with arbitration, whatever might be the arbitration, whether domestic, international, or any sectors, or even statutory arbitrations to some extent. This is the only law which governs. Due to some economic factors or judicial precedents, we have now 3 amendments: 2015, 2019 and 2021 amendments, and fortunately or unfortunately now they are going to have a new structure, an amendment bill 2024. In the year 2025 it might be notified. This law, how to just look into, how to analyze, how to implement, that is my task to convey to all of you. Okay. This is one definition what I wanted to specifically bring to the notice to all. If you look into in any law, similarly the first section would be the short title, second would be definition. We do have. But looking into the arbitration law, they have tried to define multiple terms, including the term arbitration, the term party, the term arbitration agreement, the term arbitrators. These are major terms we can come across. One example I have taken here. Section 2A tries to define the term arbitration. And what you can find in that law is that arbitration means any arbitration whether or not administered by a permanent arbitration institution. Looking into this definition given in the law, can you understand the term? Yeah, I'll come to it later. But just this is the exact wording of that definition for the term arbitration. And the other one which I have not highlighted before going in detail, arbitration agreement, they are just given. Arbitration agreement means an agreement referred in accordance to section 7. The lawmakers are very smart. They didn't try to define this term and they were not interested to confine this term to a specific understanding. It gives us a great opportunity to positively interpret. It's very important. Now, coming to this particular definition, arbitration means any arbitration whether or not administered by permanent arbitration institution. This law and this particular definition is not made in India. It is the United Nations Commission for International Trade Law Model Law, UNCITRAL Model Law 1985 suggested this definition. They brought in this law to recognize 2 legal systems. Most of you would know that we are following a legal system which is called common legal system, and the other one predominantly used by developed countries is civil law system. We are still developing, or we can consider as underdeveloped. But these 2 legal systems has to be brought in for this particular concept, arbitration. If you want to have an understanding of arbitration in detail, under common law there will be a great definition, some 10 lines. But this is actually from civil law. It is a broader understanding. We had to be broader when we are coming to interpret a particular term. The term arbitration, normally when we use, with due respect, there is one, the chairperson, Miss Geeta, she's here? She might coming, okay. With due regards, if I am just asking, the chartered accountant Geeta ma'am is acting arbitrary. Follow this term? That person is acting arbitrary. That means, what's the meaning of it? Independently on their own. Further, I need the crack of it, the term. Not by the rules. It is their own discretionary authority. I am acting arbitrary. I was just given by this, but I am not so comfortable with this column mic. But still, it is his arbitrary act because he wants it can be recorded perfectly with the audio. And right now, my good friend also is entering. Narayan is inside. Still, if I am not using this and I am just taking this mic, that is might be convenient to me, but it is not suitable for this camera to record the audio in the perfect manner so that it can be used multiple times to educate others. But here the term arbitrary would be adopted in different situations in a different manner. Now, this term arbitrary has been brought in for this concept arbitration. It is also a term equivalent to a discretionary authority given to an individual, a private individual, to resolve the dispute, but within the perspective of the legal principles. That is very important. If it is not happening within that legal principle, it becomes panchayata, gangaru panchayata, what we call. Earlier we used to mention mediation also, like now that also is likely to be governed by a law. A Mediation Act 2023 has been enacted, not totally notified. Coming to this term, it is very clearly mentioned that they are recognizing the term, but it is specifically mentioning not admitted by permanent arbitration institution. Such a thing has been included. First of all, we have to understand this process is quite away from the court. The law courts are not allowed to facilitate, the first condition. Second, the sitting judges are not permitted to sit as arbitrators. Third, the epic legislations like the Code of Civil Procedure as well as the Indian Evidence Act, the new one also, is not applicable to this process. Fourth, there is no registry to monitor and facilitate this process. 5. There is no specific conditions wherein the rules and regulations of any substantive law would be directly applicable. Everything is outside court, no way connected to the procedural laws, and it is not actually even accepting the basic principles of constitution. This is all for commercial transactions. And if such a process is going to happen and there is no registry, obviously there is no a statutory body or registered body to manage or facilitate it. But still, we can also have some institutions which are considered to be at the time in 1985 like the Permanent Court of Arbitration. You have heard about International Court of Justice. Similarly, there is a court for arbitration which is PCA in Hague, which was created to handle arbitration between countries. That's how it started. And this law was created not for our benefit, not for our local transactions, it is for the investors. It is an outcome of the Uruguay round, the principles laid down in the GATT and the GATS, wherein if you want to have a globalized society, we need to have commercial laws which are going to facilitate, particularly create a good investment climate. That is the very basics of the 1996 Act. And because of that, they were not inclined to confine the definition with one system which not accepting that is a common legal system. They wanted to bring in the civil legal system in all our process. But still, it is working very well. This is the structure of this law. There are 4 parts in the Arbitration and Conciliation Act. Part 1 deals with domestic as well as international arbitration having the place in India. Part 2 is about a foreign seated arbitration when that arbitration award is likely to be brought in inside India for enforcement or execution, then part 2 shall apply. Part 3 is about conciliation. Most of you would have heard about labor conciliation, commercial conciliation. This is likely to be repealed by the Mediation Act 2023 once it is totally notified. And part 4 is the supplement of the miscellaneous provisions. For us to understand, we have to focus much on the part 1 of this law. What this law says and how it is structured and to what extent it is facilitating the arbitration process and to what extent it is permitting the court to facilitate the arbitration process. All the things is covered excellently. Here, one thing we have to just look upon the convention which is given in the last, New York Convention. Many of you would have already gone through, but as a repetition, in the year 1958, after the Second World War, a lot of commercial transactions were happening and arbitration also was developed in other jurisdictions. They want to have an enforcement mechanisms. Very simple. Arbitration can happen in any part of the world. If you are quite keen, you can just have any seat, any place. There is no restriction. Even in India, we can just go to any part of India and do arbitration. There is no impediment, no obstacle. It's all depending on the cost, what you are going to incur, and the facilities, what you are going to avail in that particular locality or the venue. Similarly, for cross-border transactions, if you are dealing with a foreign party, it is not that we have to end up in India or the other party's jurisdiction, territorial jurisdiction. We can go to a third country and even arbitrate. An Indian and a Sri Lankan party need not arbitrate in India or in Sri Lanka. We can just go to Singapore, we can go to US, you can go to Pakistan, any part of the world. The only thing is that that particular country should have a similar arbitration law. No doubt, this convention gives us another opportunity, an outcome given in an arbitration seated in any part of the world, and if that particular city or town is in a country which is a member state of this convention, then it can be enforced in India as well as in some other country. More than 164 countries have ratified this convention. This makes us to arbitrate and avoid litigations. Don't go to the courts, go to arbitration because of this. This is a value addition given in the year 1958, and India was a country who were initial signatories, and we ratified during October 1960. This is a skeletal of this act. Okay. Coming to, before going to the core element of the law, I'll highlight first the amendments. Why these amendments, and just then we can get back to the original structure of that law. Some interesting points have been highlighted. For international arbitration, go to High Court. Arbitration award can be given or has to be given within 12 months, further extension up to 6 months. Arbitral tribunals can also grant interim measures of protection. There is a model schedule of fees, fourth schedule was included. Fast track procedures was introduced, that is, an arbitration can be completed within 6 months with one arbitrator. Arbitration institutions shall be designated to appoint arbitrators. Time limit for the juridical challenges be raised, and allocation of cost, which is very interesting subject to all of you, a regime was brought in, and automatic stay provisions was removed. I'll explain. It's a very interesting thing. Why this amendment was brought in and what was the purpose and to what extent it is successful. The first one, relevant High Court. As I earlier mentioned, there are two major categories of arbitration. One is international, and in a softer way, and there is few more, we have ad hoc arbitration and we have institutional arbitration. You are asking about permanent arbitration institution. First we can understand that ad hoc and institution, then comes to domestic and international. When you are going to arbitrate based on the Arbitration Conciliation Act, then it is just ad hoc, and in that if you just an institution like I think CA Institute has an arbitration center in the headquarters, and where they impanel arbitrators and planning even administers dispute. If an institutional rules is applicable for your arbitration, then that becomes institutional arbitration. Okay, I can make it even more simpler so that you can have a good time Saturday morning. Most of us would have already got a chance to, whether it's good or bad, we got. And we didn't have a choice. We accepted what was given. Both way. That means we opted for arranged marriage. Now, presume that you are getting a second opportunity. Presume. Not going to happen. Now, you are given an option. Whether you want a choice-based marriage or an arranged marriage. Which one you like? This is the second chance. Anyway, hypothetical chance. Choice-based. Why we want choice-based marriage? What is the advantage we have? Pardon? Okay. Our choice has been appreciated. That is, we already had an acquaintance. Fine. That will work out very well for long. Any other advantage? Okay. Mutual growth without hindrance. Fine. Any other advantage? Pardon? Aligning of thoughts. Well balanced act. We do have certain advantages. For every system there we need to accept certain disadvantages also. What might be the disadvantage? Pardon? Okay, there is high possibility of breakup. Easy breakup. Okay. Any other disadvantage? I thought that would be an advantage. Any other disadvantage in it? Social? Social stigma. Okay. A modest input. Obviously not getting the family support as well as no financial support. Fine. A balancing advantage and disadvantage we have when it's going to choice based. Anyone is opting for arranged second time? Presume that one among you is going for that second chance also with that. What's the advantage in it? Arranged. Yeah, the support mechanism is there. Structured supporting mechanism. Protection not to dissolve. In a CA language, not to dissolve. What disadvantage we have? Okay, unwanted traditional systems have to be accepted. Some advantage and disadvantage of both systems we just was highlighted here. But when it comes to arbitration, just compare. Ad hoc is like choice based. Institutional arbitration is like arranged. Which one you'll choose? No other option, we have to go for institution. That institutional part is definitely recommended in this amendment 2015. Particularly, designate arbitration institution to appoint arbitrators. Why? Because they have mentioned international arbitration relevant high court. In the 1996 Principal Act, when you have time, later you just have a reading. Section 2(1)(e), which speaks about or gives a definition for the term court. And if you read the definition of the court, it is not a normal understanding of the procedural law. It says a court means a principal civil court in a district and includes a high court exercising ordinary original civil jurisdiction. It might be too legal, but no other option. We have to understand that, very important. I'll repeat, principal court in a district and includes a high court exercising ordinary original civil jurisdiction. This was the original version of the 1996 Act. In 2015 it got amended. I'll take an example of a city, Madurai. Most of you know Madurai. In Madurai, we have any courts? Yes. We have all type of courts, including an high court, which is not called Madurai High Court. It is called Madras High Court Madurai Bench. Keep that in mind. This is one example. Another one, you can take a city in Maharashtra, Aurangabad. In Aurangabad, whether we have high courts or courts, we do have courts, but for better understanding is that there is also high Bombay High Court, Aurangabad Bench. In Maharashtra there are 3 benches, one in Aurangabad, one in Nagpur, and the other one is in Goa. Okay, these 2 examples I have taken. Now getting back to Madurai. In your arbitration clause, the place of arbitration is mentioned Madurai. Okay. And that contract is involving cross-border transaction. And the parties are also coming from different countries. One Indian party and another, same example, Sri Lankan party. Commonly it happens in Madurai. When you are going to arbitrate or going to invoke arbitration, before arbitration, we need to sometimes protect the subject matter. For that, interim measures of protection can be sought in the courts. There is provision. And the law says that, looking into this definition, the 1996 version, original version, whoever might be the party, if the seat is in Madurai, that is within India, then part 1 of the act would apply. And if part 1 is applicable, the definition of the term also applies, because it is in 2(1)(a) within part 1. The international dispute, we have to go to the principal civil court in Madurai. That is the principal district court in Madurai. If you go to that PDJ court in Madurai, to what extent we can get a proper remedy, not for the Indian party, what will happen for the Sri Lankan party? They were not interested to arbitrate. They were not interested to litigate. They wanted to arbitrate. And due to some reasons, valid reasons, they have to go to the courts to get interim relief. Here, when I was mentioning the definition, I mentioned including a high court exercising ordinary original civil jurisdiction. In Madurai, there is a high court bench. Can we approach to the Madurai High Court? Madras High Court and Madurai bench? We can't go, because the bench of that High Court exercise only 2 jurisdiction, one appellate, another writ. Nothing beyond that. If the same dispute, assuming that the seat is in Chennai, can we just approach the High Court? Yes, because the Madras High Court has original site civil jurisdiction. Okay. Coming to the second example of Aurangabad. In Aurangabad also same applies. In Aurangabad, if the seat is agreed or the place is agreed, we had to approach to the principal court in Aurangabad, because there also it is not the principal seat, only the Bombay High Court has original site jurisdiction. Third example, if the seat is in Bangalore, in Bangalore, whether we have an High Court? Yes, Karnataka High Court is there. The same dispute is seated in Bangalore. Which court in Bangalore we can approach? The principal civil court or the High Court? You can't enter into the High Court. The reason is, the Karnataka High Court doesn't has original site jurisdiction. In India, Madras High Court, Bombay High Court, Calcutta High Court, Delhi High Court, Himachal Pradesh High Court, Allahabad High Court. Only these High Court has original site civil jurisdiction. That means during British period, these were the places where the Britishers had the court, which were acting as trial courts. After independence, when these trial courts became high courts all of a sudden, their chartership was continued. And when they are going to continue, their original site rules also continued. That means in Chennai, if you are having a civil case, forget about arbitration, and the civil case values around 20 crores, a normal civil suit, you need not go to the court of first instance in Chennai. We can straight away file a civil suit in the Madras High Court. The same case happens in Bangalore. We have to go to the trial court in Bangalore, that is a subordinate court, a sub court or a district court, depending upon the pecuniary value. We can't straight away come to the High Court. That is the reason why in India, Chennai, Bombay, Calcutta, including Delhi, are considered to be the best place to arbitrate. Only for the reason, whatever might be, whether it's domestic arbitration or international arbitration, we can approach the High Court. All other places, the worst example, many of you know the state of Jharkhand. Resourceful state, highly resourceful state, and the largest international arbitrations all happen in Jharkhand. Whether you like it or not, the seat of the arbitration, international arbitration, happened in Jharkhand. Imagine all the principal district courts in the prominent districts were dealing with international arbitrations also. A very famous case you would have heard, Bhatia International. In that case, a principal district court dealt the entire international arbitration and he spoiled the arbitration. It was a Ukrainian company for some iron ore trading. They ended up in a principal district court and it created a bad impression for any party not to arbitrate in India, whatever might be the arbitration or the dispute value. To overcome that, in this amendment, they brought in, if it is going to be an international arbitration in India, the section 2(1)(a) definition is relaxed. It will be applicable only to domestic arbitration. It is not going to be applicable for international arbitration. International arbitration, you need not end up in the principal civil court in that particular district. We can very well go to the High Court within that province or state. It is a good development. Second one is a very interesting one. We always say parties are going to arbitration to save time. The 1996 Act, a wonderful masterpiece legislation, didn't specify a time frame. Nothing wrong, because internationally it was not recommended. We can't just ask. Every individual might differ. I might be a quality of doing an arbitration within 2 years. Ma'am would be in the quality of completing within 6 months. Everyone might differ, depending upon their capability, the time what they are spending, the expertise, all matters. And the cooperation parties also. That might be the reason they didn't bring in the time frame. But later, arbitrations presided by so-called retired judicial officers were going on for 5 years, 6 years. Sometimes 50 to 60 hearings in arbitration. You might have heard about hearing fees those days. Per sitting they'll charge 1 lakh. 50 hearings, one arbitrator 50 lakhs into 3. 1 crore 50 lakhs. And there is no conclusion in the arbitration. No award. That was the situation. And the lawmakers wanted to restrict it, bring a time. And the first time in the 2015 amendment brought in a time. The interesting phenomenon was that from the date of reference to arbitration, the arbitrator has to complete the arbitration within 12 months. In the 2015 amendment, it was for both domestic and international. In 2019, they moved for international, but in 2015, for both. 12 months was given for any arbitrator, whether retired Supreme Court judge or High Court judge or lawyer or chartered accountant like us. It is common. And further to this 12 months, if the parties could agree, another 6 months can be, with the consent of the parties, can be stretched. That means 12 plus 6, 18 months, 1.5 years. If you look into the section 29 capital A of the 2015 amendment, it clearly says time given for passing award. 12 plus 18. 12 is the mandated period. 6 if the parties agree. And beyond that, if the matter is going to be stretched, then it is going to be automatic termination of the proceedings. The arbitrator has to complete, or the arbitrator has to approach the court and sought for extension. The court is the final discretionary authority to grant extension. The same 29A it is given. This structure was brought in 2015. It worked out very well for mid-sizes claims, not for larger claims and complex dispute. And in 2019, it is not highlighted here. In 2000, excluded, 29A excluded. The time which was given in 2015 as 12 months, further extended 6 months, there was a leverage in 2019. Instead of 12 plus 6, they added one more 6 in the front prior. The first 6 is from the date of the appointment of the arbitrator, or the day when all the arbitrators receives the communication stating their appointment. They have a leverage of 6 months wherein the parties have to file the statement of claim and statement of defense. That is a pleading, normally what we call the pleadings or the documents, for 6 months. Once the pleading is over, or it is not completed anyway, whatever might be, the 6 months is over, from that 6 months 12 months is given. 6 plus 12, and this extended 6 also is still prevailing. After 2019 amendment, now it is 6, 12, 6. Totally 24 months, 2 years. Good development, reasonable, but unfortunately, even after having this 12 going to 24 months, or 12 plus 6, 18 going to 24 months, many arbitrators are not in a position to complete. And in the same 2015 amendment, they anticipated certain things like fees, as well as to what extent they can complete the arbitration within the 12 months. The fees part, in 2015, before 2015 we didn't have any proper structure of the fees. Assuming that, I'll take an example of one of you, sir. Assuming that you have been given an opportunity to arbitrate in a dispute of the same 20 crores Indian rupee, what would be your fees? What fees you will charge as a sole arbitrator, or how you are going to determine? Any guess? Anyway, I am not going to give you. Percentage, yeah, you can just come out with the figure so that it will be helpful. 1%. For 20 crores, 1% means 20 lakhs. You are too modest. It was a discretion of the arbitrator when it comes to fixing the fees in the 1996 Act. Whoever might be the arbitrator, they have the authority to prescribe. And as a party who is invoking the arbitration, they will be ready to pay whatever the fees they are going to fix. And it was going to the level of about 3 to 4% of high value disputes. Normally the ratio has to be higher the value, the percentage has to come down. It was not happening, it was shooting up. Now, in 2015, a fourth schedule was included. And the lawmakers, when they are including that fourth schedule, they had a small title on the top, model fee. They didn't put mandatory or statutory fee. They mentioned model fee, very small letters. Even now if you look at the Barrett or whatever soft copy, small model fee. And they were not interested to confront with these retired judges when it comes to fees. And it has a like an income tax slab, less than 5 lakh the disputed amount, if you can quantify the claim. Less than 5 lakhs, 45,000 was the fees for sole arbitrator. And if it is 3 arbitrators, it is going to be into 3. And they stopped till 20 crores. Up to 20 crores, they fixed 30 lakhs. 30 lakhs. That's what I mentioned, you are all modest. But they stopped beyond 20 crores. Above 20 crores, it is going to be upper ceiling of 30 lakhs for a sole arbitrator. If it is 3 into 90 lakhs. And if that arbitration is with one arbitrator, there is a small note in the bottom. It says, if it's sole arbitrator, that arbitrator is entitled for additional 25%. 30 lakhs plus 7.5 lakhs. 37.5 lakhs is the upper cap for domestic arbitration in our country. Even for a dispute value of 1000 crores or 100 crores or even 21 crores, it is going to be 37.5 lakhs. And if the respondent, other party, comes with a counter claim, similar counter claim, it can be plus 37.5. That is the maximum. It is not good for senior arbitrators, very, very low fees. But this development in the law is a very interesting development, wherein now parties are interested to come to arbitration because they can predetermine and have a proper budget before going to arbitration. It's a very great development, so that the parties can determine, they can just allocate a budget. This is going to be our cost in the arbitration. In arbitration, the cost, according to the law, in section 31, there are 4 heads. The major head is arbitrators' fees and expenses, including witnesses' expenses. Second, legal fees and expenses. Third, institutional administrative fees, if we are engaging institution. Fourth, miscellaneous expenses. 4, legally it is being termed. Arbitrators' fees and expenses, now at least we have a structure. It is good. They can determine. Legal fees and expenses, we can't just anticipate. Sometimes lawyer or the representative, it's not that always lawyers have to represent, anyone can represent. Most of the arbitration, chartered accountants are representing the parties in arbitration. That is very, very good development, and they are the best person. But unfortunate thing is that a lawyer would charge high than a chartered accountant. I'm not sure what's the reason behind it. It's ulta when it comes to arbitration process, not like a tribunal process. But the legal fees and expenses, something different. Arbitrator fees, now we can determine. Here comes a combo wherein model fees for arbitrators and designation arbitration institutions appoint arbitrator has a direct proportion. I'll try to explain why and what's the reason behind it, and the law, the overview of the law of this country in arbitration. Normally, how you are choosing the arbitrator for your clients? When an opportunity is given? By reference. By reference means any direct source or indirect source?
Probably indirect.
Indirect source. Assuming that in my dispute I wanted to appoint you, I should have some valid reasons, a research done to choose you. A proper way of bringing you as an arbitrator, you might have published some article in some journal or some magazine. And in that journal or magazine, a opinion, a recommendation you would have been given, or a particular legal point you would have addressed, wherein I have a similar case. And your recommendation would be my right. In that way, I will try to reach. It's an indirect reference. Looking into that article, I might reach you, sir, are you interested to arbitrate? Very simple.
I can act independently.
I'll come to that point later. For me, I am the party, agreed party, I'm not worried about all these things. I expect to have a person to arbitrate who is going to favor me. Very simple. A person who is going to appreciate my right. I will approach only that person. I won't just randomly go, that is the best person in the world. Independent, impartial, unbiased, fair, whatever, man of integrity. I won't choose like that. If I consult my lawyer, he will say, no, he's the right person, he is a honest person, but his understanding of that law is like this, which might favor me. That is the reason why I might rush. If I approach you as an arbitrator, you will give your consent. When it comes to the other party, whether she will accept? Not necessary. It's not that always. And there won't be mutual consent. The law permits. I can propose, the other party can accept. And if she is not accepting, where I have to end up?
Let him choose.
She will propose. She will have another name, not your name. That name I won't accept. It's very simple, normal understanding. And we can't have an arbitration with two arbitrators. The law in section 10 is very clear, settled. Even number of arbitrators is not permitted, only odd numbers. It can be 1, 3, 5, 7, it can go on to have the simple majority. Now, to even agree one arbitrator is not so easy. And ultimately, after 30 days, if she is not accepting or her name I am not accepting, I have to rush up to the High Court. Under section 11 of this same law, which are yet to be changed, those laws are very, the provisions are very clear. We have to go to the High Court, and the High Court is going to appoint, and ultimately High Court would appoint a person with judicial experience. The best person, 30 years, 40 years, good experience judging people, deciding the law, looking into the facts, analyzing properly. A retired judge, nothing wrong. They do have list or panel of arbitrators, but they have the preference going to the retired judicial officers. Once he's been appointed, then he has to follow this law. And in the same 2015, the law, as an understanding, presumed that our good friend is appointed as an arbitrator by the High Court. Now, it is not going to be a smooth ride for him to start. He was mentioning that I will be neutral. That's right, no sir? You are saying, but I might accept, she might not, even though you are appointed by the High Court. Very, very important. You have to give a written declaration before actually starting the arbitration. And for you to declare, in the 1996 original act, nothing was there. In 2015, 5th schedule and 7th schedule was included. Very, very interesting for all of you to learn later, have a reading later. 5th schedule, there are some 34 categories of relationship you have to read, analyze, and something is there you have to declare. It is not only confined with you, along with you, you have to look into the radar, your close family members, and the parties. As parties, there might be some affiliate wherein you or your close family member have some professional relationship, personal relationship, business relationship, and relationship of any other kind. All these terms are not created by me, all created by the law.
To avoid conflict of interest.
Yes. It is really the best practice, but if you are going to act as an arbitrator, whether we are mutually agreeing or even default the court is appointing, you have to undergo the test. The court might also have chosen the wrong person when it comes to independence or impartiality. And if you look on, between 5 and 7, 6th schedule, they included a template also, a format they have given. Wonderful format. You have to give your name, your contact details. Don't give your mobile and email, just your postal address. And interestingly, they are given your past experience in arbitration, then how many ongoing arbitration you have to fill in, then looking into the fifth schedule, circumstance likely to create reasonable doubt against your independence and impartiality. If you look into that list category and with your past experience, somehow we will come within those. Somehow we will come. Past consultant, advisors, business relationship, our close, even purchasing a share is vulnerable if you are going to arbitrate. Don't purchase share if you want to be an arbitrator. Don't allow your close family members. And in that also they are defined. Who are the close family members? Spouse, siblings, parent, children, life partner. They are quite advanced. Life partner is actually not defined, but they have added in the arbitration amendment 2015. And here, if in that fifth schedule, if your relationship comes from 1 to 19, first 19, all is being reproduced in another schedule, that is 7th schedule. And if your relationship comes within that, the next line comes, you are ineligible to act as arbitrator. Gone, your opportunity. This is with reference to one section, that is 12, in section 12, subsection 5, a new addition in 2015, wherein now we are going to appoint an arbitrator with clear hands. It is very clear the arbitrator beyond all these tests would be the right person to decide. But all these should happen not within a month or 2 months. It has to happen within a day or two. A declaration has to be given. Not so easy. Here, the law not only gives this time, the fees, it also gives an opportunity that here, instead of the court, when it comes to the High Court appointing arbitrator, the High Court can also designate institutions to appoint arbitrators. Permanent arbitration institution. There are some arbitration institutions in India and outside India. The most, the oldest one is the Indian Council of Arbitration. Many of you, if you have experience with public sector undertaking, Indian Council of Arbitration is a traditional clause would be included. There might be some larger contracts with ICC clauses, International Chamber of Commerce, Court of Arbitration clauses. Quite an expensive process, but still it is the best process outside of India. Such institutions, now the law has started to promote. And in the same amendment, including the 2019 amendment, there was an introduction to establish Arbitration Council of India. This is the major takeaway in the initial process of this amendment or the law. All of us can also act as arbitrator in future if you get accredited as an arbitrator with Arbitration Council of India. I'll just give a 5 minutes final touch on it later. Further, these 2015 amendment also deals with two other technicalities, or before that, fast track procedure. There was an inclusion, section 29 capital B, fast track procedure, which specifically mentions that we can have an arbitration with one arbitrator, that is a sole arbitrator, and that arbitrator has to complete that arbitration process within 6 months, and the process need not be with oral hearing.
they can have a process which will be identified as documents only arbitration. In India, we do have many documents only arbitration, like if you come across domain name disputes, recent development, there is a internet exchange called NIXI, wherein if you have a dispute pertaining to your website, example ICAI.org, it is the institute website. If a similar person gets ICAI.in and do some unwanted things to spoil the reputation of ICAI.org or to take away the business, a competitor, it's called cyber squatting. This dispute need not go to the courts. This dispute can go to the arbitration, but that arbitration is under a separate body, NIXI, and that arbitration has to conclude within 21 days. No oral hearing, entire documents only, not even online, entire documents only, and the award can give only two reliefs. One, cancellation of ICAI.in, another cancellation and transfer of ICAI.in to ICAI.org. That's all. This is one example. And in your securities market, many of you already get involved in listed companies. There are multiple investors. You know about the investor grievances platform, where SEBI has wonderful rules and regulations and well regulated. If a dispute comes, there is a grievance for the investor against the brokers or who be the MIIs, institutional facilitators, or who might be participating in that exchanges. If a dispute comes, no dispute comes to the court straight away. It has to go to arbitration. Earlier days, before arbitration, we had to go to Grievances Redressal Committee. Many of you would have heard about GRC. Now it has changed as conciliation. Then go to arbitration. Then go to appellate arbitration. Then come to the court. So that maximum the disputes would be resolved within the in-house process. Don't come to the courts. That is objective. That is also one example of documents only arbitration. Mostly. We do also have oral hearings, but predominantly documents only is preferred. They wanted to bring that practice in a normal commercial arbitration also with fast track. And in the 2024 proposed draft amendment, they are also trying to bring this securities market appellate arbitration process within that law. Don't come to the courts once an award is given. Try appellate arbitration, then come to courts. So that they wanted to minimize commercial disputes coming to the courts. Anyway, I think Sriram would accept halfway. Okay. These are some amendments what I wanted to highlight in 2015. In 2019, as I earlier mentioned, the Arbitration Council of India, which is going to give all of us an opportunity to arbitrate. Whether you are a chartered accountant, whether you are a cost accountant, whether you are an engineer, whether you are a lawyer, whether you are a normal graduate, whether you are an individual above 18 years of age, everyone can arbitrate with certain criterias which are likely to be created by ACI. As of now, we don't have the clarity what they are going to bring. This was also facilitating a particular schedule, 8th schedule in 2019. This prompted your institute to make you all understand that you all are going to be arbitrators. This 8th schedule was brought in 2019, but in 2021 it was removed. Now it is not that, but this has given an opportunity that who are eligible to arbitrate. Looking into the 1996 Act, we can't find the qualification for a person who can be appointed as an arbitrator. If you have a reading on section 11, subsection 1, it says, unless otherwise agreed, a person of any nationality can be appointed as an arbitrator. That's all. Anyone. That person, quality, independent, impartial. That's all. That's enough. Other things, he can appoint an expert. That expert would help and he will come to a conclusion, give the award. This 8th schedule gave an opportunity not for youngsters, people with 10 years experience or above can arbitrate. Qualifications were prescribed, some 7, 8 to 9 professionals were brought in, and they also added experience for arbitrator. Not only that, experience of arbitrator, in that there was one inclusion which mentions that the prospective arbitrator has to be conversant to the Constitution of India. How many of you are conversant with the Constitution of India, including me and Sriram, you can add? You are conversant?
At least the primary article.
Primary articles, at least he has, because he is still into litigation practice. I just missed out many. Honestly speaking, I forgot, except the fundamental rights. How we can expect non-legal persons, non-legal professionals to be conversant with the Constitution of India? This was a major obstacle to remove that. Experience, qualification fine, experience, they wanted this. We can't have a foreign arbitrator here. We can't have an Indian arbitrator going outside. Multiple factors got involved and they wanted to remove that particular 8th schedule. But now that has given an opportunity for all of us to understand that who all can become an arbitrator, and this is the basis for creation of the Arbitration Council of India. Sections 43A to M deliberately deals with that. Okay. This is the latest changes what has been proposed. Anyway, I'll have, I think I have a reasonable time till what time? 12? 12 or 12:30 schedule? Okay, fine. This changes which was suggested in 2024, Dr. T.K. Vishwanathan committee recommended this, and we are going to have a new set of provisions in the arbitration law, but as an advanced understanding of provisions, we have to understand this particular concept. Emergency arbitrator. I heard about this. We are speaking about arbitrators, we are speaking about learned arbitrators, we are speaking about appellate arbitrators, something emergency arbitrator. What might be this term leading us?
To avoid
Unusual, okay. I'll put it like this. We do have the arbitration clause or the agreement. Everyone would have seen it. To invoke the arbitration clause, how long it will take? At least a month. We have a lot of discussion, deliberation. We had to take a call whether to proceed or not. Okay, finally we had decided we can invoke. When you are invoking, technically the arbitration proceedings commence. The day when the opposite party receives that particular intimation invoking the arbitration, it starts. When the arbitrator would be appointed? At least? Pardon? A violation. When? Any time. We are starting the arbitration. The commencement is there. If you look on section 21, commencement of arbitration proceeding is simple, 2 lines it will be there. The day when the opposite party receives the notice informing invocation of the arbitration, that's all. And after that, they have to appoint the arbitrator. Appointing the arbitrator, sole arbitrator, minimum the law itself prescribed that they might take 30 days. Already 1 month has gone, another 1 month. If similar example, they couldn't agree, we had to go to the courts. The 1996 Act was silent, no instruction given to the courts, High Court particularly, when to appoint. They were taking 3 years, 4 years to appoint. And 2015 amendment, there was a wording given in section 11, the High Court shall make an endeavor to appoint the arbitrator within 90 days. Already 30, 60 has gone, now 90. 150 days is minimum. We are getting an arbitrator appointed. 5 months. The opposite party's counsel, what advice he will give? It can be extended, but the subject co-element, the subject issue, how to deal with it? We have to preserve the core subject issue. We have to safeguard that. Some process, some mechanism should be there to preserve it. After that, if you get an award and nothing is there, how to just realize with that award? We can enforce it. Nothing would be there. We have to protect. There should be some interim measures of protection. Conservatory measures should be there. And originally in the Act, Section 9 was there, which was speaking about interim measures of protection given by the court by the request of one of the party. The party who has invoked the arbitration also have to preserve the subject issue in hand. In courts we have option for getting interim injunctions, attachment before judgment. The Civil Procedure Code gives multiple opportunity to preserve whatever the disputed subject issue. We can even get an order not to alienate the immovable property. Multiple interim measures of protections are available. In arbitration, for that 5 months period, where to go? Our opportunity is that commence the arbitration and rush to the courts. And the court has to grant interim measures. No doubt, they have 360-degree power. And interestingly, there is one subsection in section 9 says that the court can grant interim measures which it feels just and convenient. That means 360-degree power. It's an excellent authority given. They can give, but it also takes some time. Section 9 relief, it can even take a week or 10 days or even 1 month. Instead of going to the courts before a normal arbitrator or the permanent arbitral tribunal is constituted, a new concept, a Singapore-based concept, emergency arbitration is included. Earlier days when they were mentioning about or reading, they will mention EA. In Chennai, if you address EA means Express Avenue. Now it is applicable for emergency arbitrator as well as emergency arbitration. And the greatest example many of you would have seen in the national dailies about Amazon future dispute. I heard about it. There was an arbitration in Singapore and Delhi High Court was involved. What are all these? This was about an emergency arbitrator's decision, which was ultimately recognized by Indian courts. Delhi High Court recognized and they enforced it. They recognized a foreign law accepting the emergency arbitrator, but unfortunately in India we didn't have a provision for emergency arbitration. This is a greatest opportunity which has been brought in or proposed in 2024. That means before an emergency, the permanent arbitral tribunal is constituted, an emergency arbitrator can be appointed. But it is for a cost. This model, which from the Singapore International Arbitration Center rules, as well as the International Arbitration Act of Singapore, which also recommends a fees for the arbitrator, the emergency arbitrator. We can't imagine the emergency arbitrator is entitled for 10,000 Singapore dollars. His role is hardly sometimes even 14 days or 20 days. He will give the order and that order stands good till the permanent arbitrators are appointed. But for a party, it is the excellent opportunity. Instead of entering the courts, making a section 9 application, they can very well appoint an emergency arbitrator. He will be appointed within a day. And that can be facilitated by institutions. In India, all the arbitration institutions already have the provision for emergency arbitrator. Only the law, we are waiting for this. Arbitration Act, we have to wait until this is being passed. We can go to the institution and the institution would appoint the emergency arbitrator. Okay, I think now we have to take a tea break. Sorry, I just forgot because I don't take tea and coffee. I just made all of you to sit. You can have it's a 10 minutes break. Efficient enforcement mechanisms. The recent amendments, no doubt, is all having an objective to make India an arbitration hub. That means we all are going to get the opportunity to arbitrate. Being an arbitrator is an excellent experience. Judging the fault is the greatest opportunity that we should not lose it. But we do have a lot of impediments to reach that. And finally, choosing the right arbitration method is very, very crucial for your business. Go with institutional arbitration. ICAI also facilitate the institutional arbitration, or other professional bodies also are already doing. If we are having the best arbitration method which is being provided by institutions, that has to be your choice. Thank you. Thank you for patiently hearing. One question. Yeah.
You mentioned beginning that most of the partnership deals are the arbitration. You also mentioned about this eviction of the tenant, the Rent Control Act being there. Because of the Rent Control Act, it cannot be brought to the arbitration. What about the partnership? Do we have a partnership act? Is that subject to arbitration?
It is when it comes to the deed, deliberating the deed, we can arbitrate. Even dissolution of partnership is arbitrable.
You say that the partner will be expelled immediately. The word immediately is there. That means it's not the period of arbitration may not be there.
It is
the intention is that way. How does it work?
Injunction, when it comes to the agreement, the partnership deed, the terms and conditions of the partnership deed, that has to be effectively handled by the arbitrator. The question of arbitrability doesn't arise. It is arbitrable. We have to understand that. It is arbitrable. The only thing, if the Partnership Act has some special exclusion on it, that cannot be taken by the arbitrator.
That means the deed cannot exclude. If a deed says that if a partner can be,
that is the intent of the parties. That cannot be overlooked by the arbitrator. It might be violative. It might be unilateral. But still, an arbitrator's authority is limited to that. Not like a judge.
Thank you, sir.
Thank you.
One more question. Initially said one thing. Arbitrator has to test himself whether they fall under negative list, ineligibility. Okay, initially assume that they are okay. They pass out all the tests, right? Later, they are in the process. Who would monitor whether he again involve the negativity or not?
An arbitrator's declaration is not confined only in the initial stages. It is a continuous process. During the process, if something comes to the knowledge of one of the disputing parties, they can very well raise it. But it has to be raised not to the court, to the same arbitrator. That is the beauty of arbitration law. It is not allowing the court to intervene.
That is the area wherein court has to have some more clarity.
If the court comes, then the arbitration has to stop. It will be temporarily injuncted. The court would take its own sweet time to decide. To avoid that, earlier it was there. The 1940 Act, it was there, we can go to the courts. Now the entire onus is given to that same arbitrator. Such a prudent person has to be appointed.
Initially, okay. Later on, we can't say.
No, I'll come to that point. That person can continue. Even he is in fault, he is continuing, he can give the award, but that award can be easily set aside. The agreed party has to wait till the award is given. He can raise that can be challenged and the court also straight away accept. Thank you.
Thank you, sir. On behalf of SIRC, I'd like to thank Inbavijayan sir for his time and effort. Okay, sir. I would like to welcome our second speaker, Advocate Sriram Venkatavaradan sir, to stage. For a short brief of Sriram Venkatavaradan sir, he is an independent legal practitioner who specializes in corporate litigation, including shareholders dispute and insolvency related disputes, arbitration and commercial disputes. He regularly appears and represents before Madras High Court, National Company Law Tribunal, National Company Law Appellate Tribunal. He also worked on complex commercial and construction arbitrations and litigations. And he also, apart from his legal practice, Sriram Venkatavaradan sir has written several articles on the areas of public policy, insolvency law, contract law and arbitration in leading newspapers, academic journals and blogs, including New Indian Express, Hindu Business Line, Supreme Court cases. He is also one of the chief specialist editors of Guide to Insolvency and Bankruptcy Code and a specialized editor of Guide to Proceeds of Crime and PMLA. I welcome you to the program, sir. And I also request CA Sivasankar sir to give away the momentum for honoring our guest. Thank you, sir. Yeah, I would like to request Sriram sir to continue the section. Thank you.
So, a very good afternoon to all of you. So, today I will be covering the topic of international arbitration process and opportunities for professionals that are available in the arbitration field. Now, in terms of international arbitration process, it's a fairly vast field. So I'll try to condense it as much because it's also going to be a little bit of procedural law involved since the complications involved are huge. So I'll condense it as quickly as possible. And the second topic in relation to opportunities, in fact, sir has also covered a fair bit of portion. So that's more of an academic discussion and I will engage with you. And fortunately, while this is a dry topic, there's an intervening lunch break for to gather your energy and come back. So that way I was fortunate that initially when I was told that it's 12 to 3 hours to speak on this topic would be a lot, I felt. But fortunately there's an intervening lunch break now. So first half I'll try to cover one segment of the international arbitration process and then move on to the procedures involved in the various arbitral institutions and thereafter move on to the topic. Now, before I commence with the topic for international arbitration process, I would like to briefly explain the arbitral process firstly so that you have a sort of bird's eye view of how the arbitral process work under the domestic arbitration law, so that when I then compare it with the International Arbitration Forum, you have a better comparative understanding of both fields. So simply put, your arbitral process under the Arbitration and Conciliation Act 1996, it commences with an agreement that is entered into between the parties that largely discuss about the obligation and rights of the parties under that contract. And let's assume that the said contract between the parties contain a specific clause for arbitration and thereafter certain disputes arise in the parties in relation to the contract, and now to refer the to the arbitration. Yes, sir. So now let's assume the parties want to refer the disputes to arbitration. They typically send a notice of arbitration which is contemplated under section 21 of the Arbitration Act, and the notice is thereafter sent to the other side expressing their intention to arbitrate. And once the notice is received by the other side either chooses to accept the nominee arbitrator proposed by the party A, or the party B proposes a different set of arbitrator altogether. Since if there is consensus, well and good. If there is no consensus, then the parties approach the court under section 11 to seek for a neutral appointment. And once the arbitrator is appointed, the arbitral tribunal stands constituted. And once the arbitral tribunal is constituted, the tribunal usually fixes up a time frame for conducting the arbitral process. Now, like sir mentioned, you have your ad hoc arbitration as well as institutional arbitration. Ad hoc arbitration is where the parties themselves decide on how to go about the arbitral process, versus institutional arbitration is, let's say, typically you have the Nani Palkewal arbitration in Chennai. So you submit to the institution, and the institution thereafter conducts the arbitral process entirely. So in the example that I had quoted, let's say it's an ad hoc arbitration, the arbitrator stands appointed, the tribunal then fixes the time frame for conducting the arbitral proceedings, then one party is expected to submit its statement of claim followed by statement of defense from the other side, thereafter a response in the form of rejoinder to the statement of defense, and once this is what we call as pleadings, once the pleadings are completed, then we move on to the framing of issues, and once the issues are framed by the arbitrator, we move on to what is called the trial stage, where both witnesses are expected to submit their proof affidavits testifying on their respective cases. And once the proof affidavits are submitted, the tribunal would then start the trial of the process, where both the witnesses are cross-examined by the other side's counsel. And once the trial process is completed, you have the opportunity of advancing oral arguments followed by written submissions, which then culminate in the form of an award being passed by the arbitrator. So this would be largely the bird's eye view process of the entire arbitration proceedings that is typically conducted under the Arbitration and Conciliation Act 1996. Now this is on the domestic front. Now if we were to compare it on the international commercial front, well, I'll just read out the concerned provisions on what would constitute an international commercial arbitration under the Arbitration and Conciliation Act 1996, because a lot of intricacies arise when you have complex commercial disputes with complex contracts containing various references to the law governing the arbitration agreement, law governing the contract, and law governing the seat. So I would get into it in the subsequent stages. For now, what I thought was I would first explain the relevant provisions for you to sort of have a grasp on how this presentation is going to flow. So the first provision that I would be explaining is section 21F of the Arbitration and Conciliation Act, which discusses about the definition of the term international commercial arbitration. So international commercial arbitration means an arbitration relating to disputes arising out of legal relationships, whether contractual or not. Now this legal relationship can be condensed in the form of a contract or not. Considered as, so I'll just read it again, means an arbitration relating to disputes arising out of legal relationships, whether contractual or not, considered as commercial under the law in force in India, and where at least one of the parties is an individual who is a national of or habitually resident in any country other than India, or a body corporate which is incorporated in any country other than India, or an association or body of individuals whose central management and control is exercised in any country other than India, or where it's the government of a foreign country. So if you see the definition, typically one party predominantly ends up being a foreign national, or it's a foreign government itself, because you have your bilateral investment treaties where two states enter into an arbitration agreement and then decide to adjudicate the disputes in the form of an arbitration under the relevant BITs, bilateral investment treaties. So under the Arbitration and Conciliation Act 1996, for you to be referred to or called as an international commercial arbitration, one party has to necessarily be a foreign entity and the other party being the Indian entity. So if this combination arises, it would be called as an international commercial arbitration. Now let's assume this international commercial arbitration kicks in and the process is officially in force. What happens under the Arbitration and Conciliation Act, and whether the award passed under the international commercial arbitration is recognized in India. So these are all the finer nuances that I'll be covering. So the next section that I would be dealing with is part 2 of the act. So I'll just So if all of you read up the Arbitration and Conciliation Act, you would notice that the act is primarily split into two parts. Part 1 of the Arbitration Act deals with all your domestic arbitrations, be it for interim reliefs like Sir pointed out under section 9, or for appointment of an arbitrator under section 11, or for interim reliefs before the tribunal itself under section 17. Now, the part that governs international arbitration process under the Act is Part 2, which is titled Enforcement of Certain Foreign Awards. Now, you typically, let's say, contracting party in India, your, let's say, Reliance, enters into a contract with another multinational based on, say, Tesla. So, they have a contract for supply of electronic vehicles, and now the contract clearly stipulates that the arbitration will be governed by the Arbitration and Conciliation Act 1996, but the law governing contract would be the laws of the US, and the seat of arbitration, that is where the arbitral tribunal will be constituted, will be US. Now in this case, let's say an award ends up being passed by the tribunal. Now the question is whether this award will in fact be recognized in India. Why this is important is, now from Reliance or Tesla's perspective, let's say they have an award in their favor. The question is whether India recognizes an award passed by a foreign tribunal, and whether such a tribunal or such an award can be enforced in India. Because the whole idea is, if India does not recognize such an award, purpose of entering into this arbitral process will be redundant, since it would simply be a paper award. So you will have to first see whether India is a sort of signatory to the New York Convention. So now I'll explain. Under Part 2, there is again a further division of New York Convention and Geneva Convention. Now these are your typical conventions that govern the enforcement of foreign awards. India is a signatory to both the New York Convention as well as the Geneva Convention, and the section 44 of the Arbitration Act clearly states that for India to recognize an award passed in any other foreign state, not only does it suffice that India is a signatory, it also needs to ensure that the award in which the state in which the award is passed is also a country that is recognized by India as a reciprocating territory. So now in the Reliance Tesla example, the list of reciprocal countries, if you see, US also forms part of it. So while entering into the realm of international arbitration, you need to first understand whether, when one of the parties is India and the other party is a foreign national, whether your arbitration clause, when it specifies that arbitration will be conducted in a convention state. Totally about 172 countries are signatories to the New York Convention and about 80 odd countries to the Geneva Convention, and both these conventions India is a party. So you would first need to see whether your arbitration clause being conducted in a specific country is firstly a signatory to the New York Convention or Geneva Convention. The second step of verification that you would need to do is whether an award passed in any of those countries would have a sort of recognition in India, because you would first need to see if India has per se recognized those foreign states as part of its reciprocating territory. Only then it would make any sense for you to undergo the arbitral process, because any other award passed by a state which is not a reciprocating territory would merely become a paper award. So then you would have no benefits attached to it, and consequently it would always be prudent to first check whether the foreign state is a contracting party to the New York or Geneva Convention, and secondly whether India has also got its reciprocal obligations of recognizing that particular foreign state. So in terms of fundamentals, this is what is going to be covered under the international arbitration process. But like I said, in domestic arbitral processes, you have a number of steps in terms of pleading, submission and trial and award and so on and so forth. In international arbitration, a large component of it is covered under institutional arbitrations, because you have your ICC, which is your International Chamber of Commerce, your LCIA, which is your London Court of International Arbitration, or you have your popular SIAC, which is your Singapore International Arbitration Center. So largely, if you see in international arbitration processes, the contract would typically state that these arbitrations would be governed by the particular arbitral institution, as opposed to your ad hoc arbitrations. For example, I am currently dealing with an international arbitration where one party is a Swiss national and the other party is based out of Chennai. It was very strange to state that the clause contained that arbitration will be governed by the Arbitration and Conciliation Act 1996, and the seat of arbitration will be Chennai, meaning that the courts in Chennai would have exclusive jurisdiction. But the clause did not contain anything on whether the arbitral process would be conducted by an arbitral institution. So in this example, all the processes for appointment of arbitrator in case of non-consensus would be governed by the Arbitration Act, and if let's say you have to approach the court for any interim relief, it would be under section 9. So in situations where you don't have an arbitral institution which is designated, then it would be an ad hoc form that would take place. But typically if you see a large part, like majority of the contracts, if you see, would have a particular designated arbitral institution which would govern the conduct of the arbitral proceedings. So now I'll just move on with my presentation. Actually, a large number of slides have been put in because I have tried to compare each institution's process for each stage of arbitration, and then try to give a comparative perspective under the 96 Act, so that you sort of have a broad understanding. So what I thought was, instead of going into each and every aspect in detail, I thought I'll first cover the fundamentals and then go into these processes largely, and then the various issues that emanate out of the international arbitration process. So when it comes to arbitration, as you are all aware, it's largely a party-centric process where parties are given the autonomy to enter into a contract with another party, and they get to typically decide what sort of arbitration clause or what sort of commercial terms they enter into. So which is why for an arbitration to even exist, more than having a contract in writing, you need to specifically have a arbitration clause in writing. And like sir mentioned, a major portion, or rather completely, our 96 Act is governed by the UNCITRAL model law, and UNCITRAL model law typically states that arbitration agreement has to be in writing. So that is with respect to arbitration process. And like I mentioned, arbitration has your ad hoc arbitration as well as an institutional arbitration, and in ad hoc arbitrations it's completely fluid, parties are free to determine the process, whereas when you submit to an institutional arbitration, your entire process is governed by the particular arbitral institution. Now, like I said, LCIA is one of the popular recognized international arbitration institution that governs the conduct of arbitration proceedings. Now, these are very basic points that I had discussed before commencing with my presentation, so I don't want to trouble reading through each of these points. Now, these are some of the popular arbitral institutions. Like Sir had mentioned, institutions on the domestic front. These are popular institutions on the international front. You have your most popular International Court of Arbitration, then you have your LCIA, then SIAC is the most sought after, and in a large number of commercial disputes in India, you typically would see a clause referring to SIAC as the institution for governing the arbitration. Then you have your HKIAC, then American Arbitration Institution, ICA, Indian Council of Arbitration, and ICSID. ICSID is predominantly for any trade disputes between contracting states. So that's a very niche arbitral institution. Now again, I had discussed on the definition of what can qualify as a international. What could qualify as an international commercial arbitration under the 96 Act, which means one of the parties would have to necessarily be a foreign party, and international commercial arbitration involves parties from different countries or transactions of business conducted across multiple countries. Now, I just read out the definition, so I'm not rereading through the entire process. So, this is to primarily give you a bird's eye view of what is going to be covered under the presentation. So first, you have your international conventions and model law. In international arbitration, about how the process is governed, you have your conventions, which is your New York Convention and Geneva Convention, that sort of shape up how the process is to be conducted and lays down certain basic criteria on whether the agreement has to be in writing, whether there has to be a notice of arbitration. So conventions on one side lay down the basic framework of how the arbitration needs to be conducted, and then you have your model law, which is your UNCITRAL model law, which goes into the finer specifics of how the entire arbitration process is conducted, including appointment of arbitrators, then submission of disclosure by arbitrators, what happens when you want to challenge an award. So all these processes are covered under the model law, and the conventions sort of govern whether, like I said, the particular contracting state is recognized by another contracting state. So the conventions have been put into place to sort of create the global harmony in terms of recognition of awards, so that when most of your trades are multifaceted and global in nature, it would only be appropriate to have a sort of common convention to recognize the awards passed in each contracting state. So the next topic is laws applicable to international commercial arbitration. Now this is a very interesting point and a slightly intricate point because there are three components attached to it. I will come to it later. Then you have your arbitration agreement. Then the entire arbitral process under subheading 4 is what I had enlisted when I spoke about the domestic arbitral process. It's largely similar because without these processes you cannot have a adjudication complete in all aspects. So even in international commercial arbitration, the processes are largely similar to that in domestic arbitration, with minor differences because each institution have their own set of rules and framework. So very minor procedural differences is all I would say. So the entire arbitral process is also something I will be covering. And fifth one being the interim relief by courts. So in international arbitration, what happens if you want to seek for an urgent interim relief from courts? So how does that process work? Then enforcement of awards, which is what is covered under part 2 of the Act, which is again an important topic because you cannot have an award passed in a country which is not recognized by India, thereby rendering it a mere paper award. Then applications of part 1 to international arbitration. This is a very important topic as well because there's been a lot of debate on whether part 1 provisions, let's say for interim reliefs under section 9, can apply to part 2 arbitrations. Part 2, like I said, deals with international arbitrations. So whether your provisions that pertain to domestic arbitrations can apply to arbitrations conducted under part 2. So these are the large set of topics that broad set of topics that I'll be covering in today's presentation. And before I proceed further, feel free to interrupt me. And if by chance the topics are a little intricate too, please let me know. I'll try to simplify it as much as possible. But unfortunately, in domestic arbitration is equally complicated. International commercial arbitration, when I get into the three foundational rules, it goes a little too complicated, but I've tried to simplify it as much as possible. Yes. Yes. A reciprocal obligation, yes. Correct. Mm-hmm. Mm. No, I'm assuming the example sir gave was venue being Singapore, right?
Venue alone Singapore.
Venue is Singapore, yeah. So,
Singapore, in that case, how it will?
so in that case, in the India-Sri Lanka example, they just simply decide out of convenience that the process will be governed by SIAC, I'm assuming. So the award is in relation to party which is from India and Sri Lanka, and they designate SIAC as the venue. So in this case, we need to first see what is the law governing the contract. So I'll just explain with a smaller background to this. So because many of you are chartered accountants, like in accounting, you have your three golden rules of principle: debit the receiver, credit the giver. In arbitration, you have your law governing the contract, law governing the arbitration agreement, and law of the seat. So typically, law governing the contract is the law that will govern the substance of the dispute between the parties. So in the Reliance Tesla example, if it's for the supply of EV vehicles to India, what will be the law governing this contract? So whether it's the US law or India law, parties are free to choose. I'm just mentioning about the hypotheticals. Then in this contract, there will be an arbitration agreement. So if the parties decide to submit to arbitration, what will be the law governing this arbitration agreement? Whether the arbitration agreement will be bound by the Arbitration and Conciliation Act 1996, or whether the arbitration will be governed by the US law. So this is also a law that needs to be typically mentioned, but predominantly if you see the arbitration clauses, it's not mentioned specifically as to whether the arbitration clause is governed by any particular law. Then you have your third category, which is the law of the seat. Now seat and venue are sort of interchangeable, but where the distinction comes is venue is typically your venue where you're going to have the arbitration conducted. Whereas seat, there is a line of decision saying when you designate a particular country or a place as a seat, that tantamounts to an exclusive jurisdiction. So in this US Reliance example, to make it simpler, let's say they decide the seat of arbitration is India, and the law governing arbitration is also the 96 Act. In this case, it would still be an international commercial arbitration with one party being foreign. Now, if this is an award passed in India, then naturally it's enforceable. Now, let's say they decide to have the arbitration conducted in US and the award is passed in US, and Reliance has an award in its favor against Tesla. Now the question is whether an award passed in US governed by the US Arbitration and Conciliation Act is enforceable in India. So in this case, if it's a New York Convention based arbitration, both parties are reciprocating territories, fortunately. So all these will be contemplated by the parties at the time of entering into the contract itself, because you are not going to randomly allocate seats or venues. So in this Reliance Tesla example, since US is a reciprocating territory, both India and US are also signatories to the New York Convention. It would make sense for you to also designate US as a venue or seat, because any award passed in US would also be enforced in India. So that I hope answers your question. So you would have to be prudent enough to choose a place which is a reciprocating territory with India and also a signatory to the New York Convention. So in the India-Sri Lanka example, SIAC is merely an institution to conduct the arbitration. You would also have to see what is the law governing the contract entered into between the parties, and what is the law, where have they chosen the seat to be. If the seat of arbitration is also Singapore, then the award is deemed to have passed in Singapore. Now the question is whether Singapore award passed is recognizable in India, and Singapore and India are also reciprocating territories, and therefore such an award passed in Singapore will be enforced in India, but there are certain parameters to be followed before they are deemed to be enforceable in India. That I'll get into. In principle, yes, they can be enforced in India. So that is the example. Okay, so now I get into the various conventions that were entered into for basically laying the foundation for international arbitration. The first such convention was the Montevideo Convention, which was established way back in 1889. And this convention typically provided for the recognition and enforcement of arbitration agreement between certain Latin American states. So as you can see, at that particular point of time itself, there was a convention entered into so that if there are awards being passed in other Latin American states, whether they can be said to be enforced in another state which is not the contracting state. So this sort of laid the foundation for recognition of arbitral awards. Now the next is the Geneva Protocol, which was introduced in 1923, and this was again a modern international convention under the auspices of League of Nations. Now that's not too important. The second one, that is protocol being replaced by Geneva Convention, is of extreme importance because we are also signatory to that convention. So the Geneva Protocol was followed by the Geneva Convention. The purpose of the convention was to widen the scope of protocol by providing for the recognition of and enforcement of awards within the territory of any of the contracting states and not merely within the territory of the state in which the award is made. So like I said, it is not enough that the award is made in the, let's say, going back to the India-Switzerland example. The question that needs to be seen is, if the award is passed in Switzerland, whether that award can be enforced in India, because firstly, is Switzerland a party to the New York or Geneva Convention, and whether India recognizes Switzerland as a reciprocal country for it to enforce the award in Indian courts. So Geneva Convention sort of laid down the foundation that it's not enough that you merely recognize the country in which the award is made. You also need to recognize that the contracting states also need to be recognized under the particular convention. Yeah, so this sort of lays a threshold in terms of recognizing an award passed by a contracting state which is a signatory to the Geneva Convention. So the principle is called the double executor. So it is not enough that the award has become final in the country of origin. Now let's say it's passed in Singapore. It's not enough that the award has attained finality in Singapore alone. The successful party would also have to seek a declaration in courts of the country in which the arbitration took place to the effect that the award was enforceable in that country before it could go ahead and enforce the award in the courts of place of enforcement. Now, if the award is passed in Singapore and it is a Swiss national that has the award in its favor, as per the Geneva Convention, it's not sufficient for the Swiss party to show that the award has attained finality in Singapore alone. It needs to go one step further to show that the award has attained finality and enforceable in Singapore before it could come and enforce the said award in Switzerland. So, which is why you have that dual step process, that simply having the award passed in Singapore would not be sufficient. You would have to necessarily demonstrate that it has attained finality there and it is enforceable there, and thereafter you can have it enforced in the contracting where the party belongs to. Now this is the second convention, which is a very, very important convention, And largely most of the, like I said, a significant number of countries are parties to this convention, about 172 odd countries. So the New York Convention was introduced in 1958, which is one of the cornerstones of international arbitration. This convention, also similar to the Geneva Convention, provides for a simpler and more effective method of recognizing and enforcing arbitral awards. So if you see, the common thread that cuts across all these conventions is to recognize and enforce an arbitral award, because that is the whole purpose and, you know, rationale behind naming a particular country as the seat or having the contract governed by the laws of a particular state. Because if ultimately after the entire arbitral process you have an award in your favor, it would not serve any purpose unless you can have it enforced in the country where the assets of that particular debtor is situated. So that's the whole point why, if you take a step back and see the purpose of these conventions, it's to sort of create a global network to ensure that you are not left remediless even when you have an award, so that if there is a company which has registered office in one place but assets in a completely different place, even though the arbitration happens in a particular place, you should have the rights to enforce it in the place where the assets are situated, because that's the whole point. Otherwise you will not realize the fruits of the award. And these conventions help you to clearly state that so long as you are signatories to the convention, even if an award is passed in a different country, so long as the convention, the particular country where the assets are situated is a signatory, you can have that particular award enforced. Yeah, so like I said, the convention's principal aim is that foreign and domestic, non-domestic arbitral awards will not be discriminated against it, and obliges the party to ensure that such awards are recognized and generally capable of enforcement in their jurisdiction in the same way as domestic awards. As simple as it sounds, it's not enough that if an award is passed in India, it's only a domestic award which is enforceable. Even if it's an international award in relation to a party which is a foreign party, they also need to be enforced and recognized in India. And how you do it? It is by being a signatory to these conventions, which is parties are always advised to carefully assess their arbitration clauses to see when they choose a particular place or venue as a seat, and when they choose a particular law as a law governing the contract, you need to be very sure that, from an Indian perspective at least, that both parties are conventions to the New York Convention, and both parties, or rather India has a reciprocal recognition of that other contracting state. Now, uncitral model law. So you have your conventions on one front which deal with recognition and enforcement of arbitral awards. Then on the other front you have your uncitral model law, and this model law has laid the foundation, like I said, for the Arbitration and Conciliation Act 1996. And this model law typically, if you see, lays down the guidelines for the conduct of an arbitral process from start to end, including, you know, seeking interim measures, appointment of arbitrators, how should the award be passed, what should be the form and contents of the award, so on and so forth. Yeah. So this slide sort of describes the difference between the convention and the model law. International conventions do not describe the way in which an international arbitration should be conducted. They simply lay down certain guidelines, whereas your uncitral model law, like I said, explains the process and details right from start to end. Model law takes the matters further. It contains detailed provisions for the appointment of arbitrators, procedure for challenge, and it authorizes the arbitral tribunal to rule on its own jurisdiction, so on and so forth. So a large part of these arbitral institutions have their rules premised based on the model law as well as on the conventions. So it's a combination of both, I would say. Yeah, so this is what I had discussed to explain the example of India, Sri Lanka, or the Reliance Tesla example. So like in accounting, you have your three rules. This is the three rules of laws governing the international commercial arbitration. This is where the real intricacies happen, because very frankly, sometimes unless I sort of pen it down and clearly analyze what these three laws are, it gets complicated. So your first law is your law governing the existence and proceedings of the arbitral tribunal, or what you call in the legalese as lex arbitri. So this typically is the law governing the arbitration agreement, and if you designate an arbitral institution, then it's very clear that your arbitration agreement would be governed not just by the rules of that particular institution, but it will also be governed by the rules of that particular state which you designate. So for the example of India, Sri Lanka, if you clearly state that the law governing the arbitration agreement alone is Singapore, then the entire process of how the appointment happens, how the interim reliefs are sought for, will be governed by the Singapore arbitration law. And if you decide to go for the institutional arbitration, which is SIAC in Singapore, then the procedural aspects of how the arbitration is conducted will be governed by the SIAC rules. Then the second is law governing the seat. Now, if you typically see 1 and 2 go hand in hand, because law governing the seat is where you decide to have the dispute adjudicated from. Now, seat of arbitration could be, in the example again, Singapore. If they decide that seat is Singapore, and in a situation where you omit to mention the law governing the arbitration agreement, then there are a number of judgments stating that the law governing the seat would be the law governing the arbitration agreement. There are conflicting views in India as well, I'll take you through that. But typically, if you fail to mention the law governing the arbitration agreement, then your fallback would be that the law governing the seat would govern the law governing the arbitral agreement. Then the third category is the law governing the substantive portion of the dispute. So in the example of contract for supply of EV vehicles, if you decide that the entire contract for supply of EV vehicles would be determined either by the US law or India law, you are completely free to determine which law would govern the contractual disputes entered into between the parties. Why all these are important is because first, from the recognition and enforcement point of view, you need to understand whether it would be prudent to designate a particular contracting state as the venue or the seat. Secondly, you need to see whether the particular country's arbitration act permits you to arbitrate on these disputes, because each country it differs. Some countries, for example, your typical oppression and mismanagement case, in India at least, they are not deemed to be arbitrable, but some countries, for example, permit it. So you need to first understand and sort of introspect whether these contractual disputes are arbitrable in the country which you designate as the law governing the contract. So which is why these three rules are the touchstone of international commercial arbitration, because law governing the substantive disputes is not so much in contention, but a lot of disputes emanate between the first two rules, that is law governing the arbitration agreement and law governing the seat. While they look very simple as it sounds, it's not so, because each time there are a number of disputes between the parties as to which law would be applicable for appointing an arbitrator, for appointing or for let's say seeking interim reliefs. So all these aspects are very crucial for you to contemplate the time of drafting the arbitration clause. Now I'll explain each one of the process. So first you have your law governing arbitration. The law governing arbitration may be different from the law of the territory in which the arbitration is conducted, because you can have SIAC as the institutional arbitration governing the arbitral proceedings merely from the procedural angle, but you could qualify that the law governing the arbitration act would arbitration agreement would be governed by the Arbitration and Conciliation Act 1996. So in that event, all your process for appointing the arbitrator, interim reliefs, or any other remedies that you need to seek would be governed by the Arbitration and Conciliation Act 1996, and SIRC would merely arbitration governing the process. For instance, party may agree that the seat of arbitration shall be Netherlands, and then the law governing the substantive disputes will be the law of New York, and arbitral proceedings can be conducted in India. In such a case, the law governing the arbitration would be the law of the seat. Like I said, where you fail to determine the law governing the arbitral agreement, then by default, seat would be the law governing the arbitral agreement. In this case, the arbitral proceedings, meaning the venue is in India, the seat of arbitration is Netherlands, and the law governing the contract is the law of New York. So in this case, you have your seat in Netherlands, you have your venue in India, and you have the law governing contract as New York. So in this case, what would be the law governing the arbitral agreement? A line of decision stating that the law of the seat would be the law governing the arbitration agreement. In this case, seat being in Netherlands, the arbitration law in Netherlands would govern the arbitration process. Yes, why again the law governing the arbitration agreement would be relevant is from all these angles. That is, what would be the definition and form of the agreement to arbitrate in that particular country, whether the said dispute is arbitrable like I said, and how would the constitution of arbitral tribunal be, and whether there are modes to challenge the constitution of the arbitral tribunal, and whether there are interim measures of protection, how would the statement of claims and defense be submitted, court assistance if required. So essentially, these are the various aspects that would have to be considered when you choose the law governing the arbitration agreement. So, which is why it's very, very important to have a specific law designated for conducting the arbitral process as well as the law governing the arbitration agreement. I think it could sound a little repetitive, but just bear with me, because it's like I said, these three laws are very interchangeable and very interconnected, so which is why it could be a little repetitive at some points. So, and one more crucial aspect to note is, law governing the arbitration does not deal merely with the procedural aspects alone, and lex arbitri deals with more than the procedural law. So lex arbitri, like I said, means the law governing the arbitral agreement. So there are two legalese that you need to be sure of. Lex arbitri is the law governing the arbitration agreement. Lex fori is the law governing the contractual disputes between the parties. So typically, if you come to courts, the judges would pose questions as to what is the law governing the arbitration agreement, lex arbitri, and what is the law governing the contract, lex fori. So some instances, disputes may not be arbitrable in some countries, and the grounds for setting aside will be different in each country. For example, in India, the grounds for setting aside an arbitral award is contained under section 34, and you have the grounds of fraud, grounds of the award being against fundamental policy of Indian law, or grounds of the award being patently illegal. If these grounds are satisfied, then the award so passed is liable to be set aside. So the point that I am trying to make is, when you choose a particular law as the law governing the seat or the arbitral agreement, it is important to see whether the said disputes are arbitrable in that particular state, and what is the methodology that you need to adopt to challenge the award in that particular state. Yeah. So next we move on to law governing the seat of arbitration. I hope, one second, I'll just see. In terms of time, I hope it's fine, right? Lunch? Huh? Okay, then we'll just break for lunch and then I'll continue the rest of my session. For example, if you don't specify the law governing the arbitration agreement, then it's the law governing the seat which would govern the arbitration agreement. So the second cardinal principle is law governing seat of arbitration. So in this, the law of the territory in which the arbitration is conducted is the law governing the seat of arbitration. Usually the seat of arbitration is designated to determine the law that would be applicable to the arbitration process in the absence of a specific designation of the law governing the arbitration agreement. So typically, if you have the law governing arbitration agreement specified, then the law governing the seat would merely be with respect to the place where the arbitration is conducted. But if you don't specify the law governing the arbitration agreement, then the law governing the seat would apply to it. That is, if you, let's say, have a contract stating that the law governing the seat is Singapore. So you nominate Singapore as the country where your arbitration is conducted, and you do not expressly state what would be the law governing the arbitration agreement. In this event, it will be the law governing Singapore which would apply to the arbitration as well. So, however, in India, the law governing the arbitral process in the absence of designation of the governing law of the agreement is unsettled, meaning it's not an absolute rule in Indian context that the law governing the seat would automatically apply to the law governing the arbitration agreement, because in India, courts have taken divergent view on whether it is the law governing the seat or the law governing the contract which would determine the law governing the arbitration agreement. Mind you, all these instances I'm talking about where you don't expressly state the law governing the arbitration agreement. So in such a scenario, whether it would be the law of the seat or the law governing the contract which would govern the law for the arbitration agreement. So in India, courts have taken a divergent view. So the first case dealing with it is NTPC, where the Supreme Court had clearly, way back in 1992, Supreme Court had clearly stated that where the proper law of the contract is expressly chosen, such law must be, in the absence of an unmistakable intention to the contrary, govern the arbitration agreement. Essentially, it's not the law governing the seat, it's the law governing the contract which would determine the arbitration agreement. Similarly, this was also followed in the subsequent decisions of the Supreme Court, where they had laid down the same ratio. That is, the law governing the contract would be contract as in the substantial nature of the dispute, like we saw in the previous session. So a similar line of decision was also taken in Hardy Exploration, where the law arbitration agreement is silent on the law and procedure. The governing law would be the same as the law governing the contract. But high courts have taken a different view. So in these two decisions, for example, the Delhi High Court and the Bombay High Court held that the contract would again be the law governing the arbitration agreement. The divergent view arises in these two decisions of the Bombay High Court, where they have stated that the law governing the seat would be the law governing the arbitration agreement. Why this distinction is important is, if, for example, again going back to the Reliance Tesla example, if your contract is governed by US and the seat of arbitration is London, whether it would be the US law which would govern the arbitration agreement or whether it would be the UK law governing the arbitration agreement. So to answer these questions, at least in the Indian context, while in this case Reliance being the Indian party, there is a divergent view in terms of which law would be the applicable law, because you will have a seat in London, that is where the arbitral tribunal will be seated and the proceedings will be conducted, but the overall contract for the tribunal to adjudicate would be the contract as per the US law. So in this case, for the arbitration to be conducted, which will be the applicable law, courts have taken the view that it could be the law of contract, and another divergent set of views that it could be the law of the seat. It's still unsettled. Now, just to give you a global perspective, the first decision on how you can determine the law governing the arbitration agreement was considered in this Court of England and Wales Court of Appeal in Sulamerica. This is a very, very important decision when it comes to international arbitration perspective. So these are the three guidelines that was laid down by the court. That is, whether the parties expressly choose the law of the arbitration agreement. If the parties did, well and good, half the issues are solved. Whether the parties made an implied choice with regard to the law of the arbitration agreement. Let us say by implied choice as in, if you have SIAC as the designated institution. By implied choice, are you governed by the Singapore Arbitration Act? Lastly, in the absence of express or implied choice, the system of law with which the arbitration agreement has the closest and the most real connection for it to govern the arbitration agreement. That is, the arbitration agreement to which particular country does it have the closest and the most real connection. That is, if the arbitration agreement is based out of, let's say, Singapore, or let's say the business is conducted in Singapore, then the question to be answered or looked at is whether the arbitration agreement has the closest connection with Singapore. Then in that event, the laws of Singapore would govern the arbitration agreement. So these are the overarching principles that the Court of Appeal had laid down for you to understand what law would be applicable for the law governing the arbitration agreement. Now, this is again a similar line of decision, so I don't want to trouble you. Yes, sir. Yes. Yes.
Thanks for that. One of the parties incorporated in India, and another party to that is incorporated in US.
US.
And the business where it has been conducted, the real connection you said, right? It is something taking place at a place somewhere in Africa, something, Uganda, okay, which is not a party to the Geneva New York Convention, something. You said that reciprocation should be there for
Correct.
right?
Correct.
So in that case, how that it works?
So in that case, then you are entering a very, dangerous zone, because firstly, whatever award you would, that would emanate out of the said proceeding would not be recognized in India, because one of the parties in your example is an Indian party. So it would not make sense for you to have your arbitration conducted in Africa, not just for venue purposes, for the purpose of law governing the arbitration agreement, because at least going by a hypothetical example, I have to verify if Africa is a reciprocating nation. To my knowledge, it's not. So if they are not a reciprocating nation and you have an award emanating out of the tribunal, it would not serve any purpose, because it's not going to be enforced in India. So you would merely have a paper decree in your hand.
Okay.
So it's always advisable to designate places where, that's why I said twin conditions are satisfied. One, it's a signatory to the New York Convention, so that you have the possibility of enforcing the award. Secondly, from the Indian perspective, whether that particular state that you nominate is also a reciprocating country. Always to be on the safer side, let's say nominate US or Singapore, because these are the preferred destination and popular arbitral destinations as well, or UK for example. Typically you can nominate these because India has a reciprocal obligation, and recently I think Dubai has also been recognized. So if you have these favored destinations, it would work in your best interest.
Okay, just to add on one more point.
Yes,
to it,
sir.
just taking, for my better understanding, just taking an instance for that. Say it's a kind of a diamond mine. It is there in Congo, something.
Congo, yes.
Yeah, it is actually been taken. The company incorporated in India is owning that.
Yes, okay.
Okay, it is owning the diamond mine which is working in, which is there in Congo, and it has got a transaction, some kind of business transactions or commercial transactions in US. So now the arbitration issues are coming, it's getting arise, right? Now US is preferring, and as well as India is also preferring to have the arbitration, this dealings, everything in UK as per your
UK.
case. Okay.
Okay.
In this case, the real business connection actually works to only, or looks to only Congo.
Correct.
Me if I'm wrong. Okay. In this case, how this actually work? Which law will govern the arbitration agreement?
So in this case, if you go based on choosing Congo, it has to be tested, to be honest, but extending this analogy, if you take Congo to be the closest connection, it would render the remedy unworkable, because enforcing it there will not arise. So it would rather be more appropriate to extend that arbitration agreement to India or US, because that would make it more workable from an enforcement angle as well. While you might have assets in the form of diamond mine in Congo, if the company has assets in India, it would be appropriate to have it enforced in India. That is, if the US party has an award in its favor.
Okay.
So yeah, that's the thing.
Thank you, sir.
So this is another decision following the previous ratio. Again, from a Singapore perspective, these two decisions specifically follow the ratio in Sulamarika. In fact, this would be an interesting example. In Anupam Mittal, the case pertained to a shareholders agreement relating to the management of the company. The governing law was Indian law, that is of the contract. However, if Indian law would have been considered as the law governing the arbitration agreement, the same would have invalidated parties' agreement to arbitrate, as oppression and mismanagement disputes are not arbitrable in India. Accordingly, court moved to the third stage of inquiry and determined with which system of law the arbitration agreement had the closest connection with, and observed that because the seat was Singapore, the law would be Singapore law. So to answer your question, sir, if you apply any of those three principles and it renders it unworkable, then you fall back on which would make it workable and how you could determine the closest and real connection test. Yeah, so now we come to the third category, that is the law applicable to the substance of the dispute. This is a fairly simple one, that is the law governing the contract itself. So when questions of procedure have been settled, it is necessary to understand that the law that would be applicable to the substantive dispute between the parties, and the principal task of the arbitral tribunal is to establish the material facts of the dispute. Okay, so this is again a fairly simple grounds to determine what would be the law governing the contract. Unlike law governing the arbitration agreement or law governing the seat, in law governing the contract scenario, it's not too convoluted because it's simpliciter a singular law. The only point of contention, at least in the Indian context, is whether it would be the law governing the contract or the law governing the seat that would determine the law governing the arbitration agreement. So only to that limited extent this law governing contract would be of help, but otherwise it's a fairly straightforward law in terms of if you choose US, India, Singapore, by default the arbitral tribunal, whichever is constituted, would have to see whether the contractual rights and obligations between the parties are valid or breached as per the laws of the state in which it has been nominated for. As simple as that. And the question of if the parties fail to choose, how do you determine it? Whether by tacit choice in the absence of express choice of law, the arbitral tribunal will usually first look for the law that the parties have intended to choose. This is the tacit choice, as simple as the meaning sounds. Or the second one is the choice of forum. That is an indicative factor to determine what would be the law governing the contract. That is one criterion for attributing a choice of law to the parties in absence of an express agreement is the choice of forum of the parties. That is, you don't have any law stipulated for law governing the contract. And for instance, you have one of the institutions in India nominated, and one of those institutions being, let's say, the ICA or NPAC, then the legal principles state that that would be a determinative factor to determine what would be the law applicable to the contract, and which in the example it would be Indian law, because you have decided that the forum would be India. This is just a factor to consider or determine what would be the choice of law governing the contract. This on the international perspective, so I don't want to trouble you too much with that. Yeah, so now we come to the next topic, arbitration agreement. So each of these is further subdivided into topics. So since there is a lot of procedure to be covered, please bear with me. I'll try to be as lucid as possible, but a little bit here and there I might rush into, so that I give you a complete perspective of the process more than anything. So with respect to arbitration agreement, as we are all aware, arbitration agreement forms the foundation for arbitration to be initiated. So the golden rule is that you need to have an arbitration agreement in writing no matter what, for you to even invoke the arbitration clause in a contract. So both international and domestic laws attach great importance to arbitration agreements because these agreements reflect the party autonomy, which is the primary principle of arbitration. So under the 96 Act, Section 7 of the Arbitration Act governs the rules for determining an arbitration agreement. So your typical way is, if it's in writing or through exchange of communications, you can understand if the parties have expressed their intent to arbitrate. And section 7 is again based on the uncitral model law. So an arbitration agreement may be in the form of an arbitration clause in a contract, or at sometimes parties can have an express agreement in itself. In international context, for example, as you would have seen, the convolutions are so much, it would be prudent to have a separate contract in the form of an arbitration clause, neatly enlisting what would be the law governing seat, law governing the arbitration, and which would be the institution governing the arbitration process, so that each and every detail is worked out and it's treated as independent of the contract. And one more principle to be kept in mind is, let's say your contract becomes unworkable, that does not in any manner mean that the arbitration agreement would also become unworkable, because the most basic rule of arbitration law is arbitration clause is severable from the main contract. So no matter what, the arbitration clause would always survive the main contract. So the dispute as to whether the contract is workable or not itself can be arbitrated. So like I said, arbitration agreements have to be in writing, and section 7, which is premised on the article 7 of uncitral model law, largely what the section hold is that it has to be signed by both the parties and it has to be in writing at no matter what. So apart from uncitral model law, even your New York Convention provides for the fact that you have to have an agreement in writing. So I've just tried to, like I said, I've tried to compare uncitral model law, New York Convention, then the 96 Act, and how each of these institutions have categorized these principles. So that's why you will see the same rule repeating in different formats in the PPTs. So the idea is to give you a comparative perspective of how these rules and acts have come into place in each of these conventions as well as institutions and the act itself. So as you are aware, any agreement has to emanate out of a defined legal relationship. So unless you have a sort of relationship in a legal sense between both the parties, there would not be any possibilities of arbitration. So apart from the fact that arbitration agreement has to be in writing, you need to understand that there needs to be a dispute and a legal relationship in place, which is what sir was explaining in the previous session. There ought to be a defined legal relationship and a dispute in existence for you to invoke the arbitration. Now we come to the arbitral process. So if you recall, I had explained the entire process starting from notice of arbitration, submission of statement of claim, then conducting of trial to award, which is what is enlisted here. Now the very first step is commencement of arbitral process. This goes to the inception of the arbitration. So typically you would have a notice of arbitration sent to the other side under the 96 Act, at least under section 21. Basically, let's take a step back and understand that all these procedures, if you look at it closely, it is from the perspective of keeping the other side informed. Because the whole idea is both parties need to understand that there is an arbitration in place and this is the tribunal that's being constituted. This is the set of claims and counterclaims that's going on. So a large component of the process is premised on the fact that both parties are in the knowledge of things with respect to the entirety of proceedings. So you commence the arbitral process through a notice of arbitration under Arbitration Act. So now before I proceed further, each of these arbitral processes, how I have divided is, I have tried to explain what is the convention methodology that is under the New York Convention, what is the method under the uncitral model law, and then what is the process under each of the arbitral institutions, that is LCIA, ICC, SIAC, and then under the Arbitration Act itself of India. So under uncitral model law, you have Article 21, which states that in respect of any particular dispute, a request for the dispute to be referred to arbitration is received by the respondent. So typically you will have to communicate your intention to arbitrate the particular dispute to the other side. Then under the 96 Act, a similar provision, which is your section 21, which talks about issuance of a notice of arbitration to the other side. Then under the ICC rules, it's a different set of procedure. Article 4 of the ICC rules deals with the request for arbitration. So typically in these institutions, if you go through these rules, these are fairly simple rules. For you to understand these rules, it's enough if you try to keep in mind the arbitral process under the domestic process, because if you compare both the processes, the steps involved in domestic arbitration is almost the same steps involved in the international arbitration process. Maybe on the aspect of interim reliefs it would differ, and how the tribunal is constituted would differ, but largely starting from notice of arbitration till the passing of award, it's just a different set of rules with each of these institutions. So I have captured each set of process under each set of institution. So without going into each of it in detail, what I would like to summarize and tell you is that all these institutions have their fixed set of rules contained under various articles, starting from when you want to invoke arbitration till how you want to enforce the award. Depending on which institution the parties choose, you would be guided by the particular arbitral institution's rules. One other factor that needs to be considered is, in ad hoc arbitration, typically when you send your notice of arbitration and then the tribunal is constituted, the tribunal then sets the timeline for you to submit the pleadings. But in these international institutions, if you take a look, when you submit your intention to arbitration itself, to make things more efficient and time bound, all these institutions require that you submit your statement of claim along with your request for arbitration, so that no further time is wasted for when the tribunal is constituted, then timelines are fixed, and then claim statements are submitted. So in all these institutions, a common thread that cuts across all of them is, at the time of submitting your request itself, the statement of claim is submitted, and when this decision is communicated to the other side by the particular institution, other side submits its statement of defense and either accepting or rejecting it. Then that particular institution, each of them have a designated court or a secretary or a president underneath each of these institutions. They go ahead and constitute the arbitral tribunal in the event parties fail to, or in instances where the parties have nominated an arbitrator, these institutions would have to exercise their stamp of approval, stating that yes, these arbitrators are not biased, you can go ahead and very well appoint the arbitrator. So unlike ad hoc arbitrations where parties agree, go ahead and choose, in international arbitration processes, when you have it conducted under each of these institutional arbitrations, these institutions, to eliminate the need for impartiality or bias, clearly state that if you have nominated, we need to put a stamp of approval. If you haven't nominated, we will go ahead and nominate it. And the question of whether 1 or 3 depends on what the parties intend, as well as what the secretary determines would be the number of choice for each of these arbitrations. So the next set of slides is essentially explaining the various set of procedures involved in each of these institutions. So in the interest of time, what I thought I'll do is I'll explain 2-3 processes with a comparative distinction between each of these institutions so that you can understand. So now coming with commencement of arbitration. So in ICC rules, it deals with the request for arbitration. So instead of a notice for arbitration, you submit a request for arbitration, and a party wishing to have recourse to arbitration shall submit its request to the secretariat. The secretariat shall notify the claimant and respondent of the receipt, and the date on which the request is received is deemed to be the date of commencement of arbitration proceedings. So in section 21, for example, of the Arbitration 96 Act, when you issue a notice under section 21 and the said notice is received by the other side, that would be the date on which the arbitral proceedings are said to have commenced. And why this is important, if you recall what sir mentioned, 6 plus 12 plus 6. So this date is determinative for when the timeline for concluding the arbitral proceedings are expired. So the request shall contain the following information. So the name, address, contact details, and the name, address, contact details of the person representing the claimant, which is typically your counsels, and the description of the dispute, which is what is the nature of contract entered into between the parties, your claim value, etc. Then a statement of the relief sought together with the amounts of quantified claims. That is, usually when you submit your statement of claim, you enlist the full set of disputes between the parties, and in the end you would necessarily indicate what is the relief prayed for, which is what you need to annex along with your notice of arbitration itself. Any relevant agreements in place where claims are made under more than one arbitration agreement, the indication of arbitration agreement with under which each claim is made. So between two parties you could have about 10 agreements. So the idea can be to consolidate all of them, but the clarity needs to be given as to which relief is claimed under what agreement, which is why this rule exists. Then all relevant particulars and observations, proposals considering the number of arbitrators, which is what I had indicated. So the parties can express their intent to choose the number of arbitrators and any other relevant particulars. So such other document or information as it considers appropriate for efficient this thing. And in the even the claimant fails to comply with any of these requirements, the secretariat may fix a time limit within which the claimant must comply, failing which the file would be closed. That is, which is why in these institutional arbitration specifically, unlike ad hoc, these institutions have a specific set of timelines that parties need to adhere to, failing which the proceedings would lapse. And now even for ad hoc, you have your section 29A, which clearly states that 6 plus 12 plus 6 would be the outer timeline within which you need to conclude, failing which, unless you have a court extension, the proceedings would lapse. So a similar approach is also adopted by these arbitral institutions to ensure that all the proceedings are conducted and concluded in a time-bound manner. Now, this is the answer to the request. Typically, when you submit a request for arbitration, naturally the other side gets a chance to respond and also submit its counterclaims, if any, to the statement of claim that we submit. Again, a similar set of particulars that needs to be furnished by the other side as well. So, with respect to the limited component of commencement of arbitral proceeding, under ICC rules, Article 4 and Article 5 indicate that you need to submit a request for arbitration along with your statement of claim and relief. And Article 5 states that the other side can also give their response and their reply statement with their counterclaims, if any. So this is how ICC deals with for commencing an arbitration process. Now under LCIA rules, very similar. Article 1 of the LCIA rules provides that a party wishing to commence arbitration under the rules shall deliver to the registrar a written request of arbitration. So again, if you see, LCIA is an other institution, London Court of International Arbitration, which is a similar international arbitral institution and a very popular one as well, along with SIAC and ICC. So if your arbitral proceedings are to be conducted by LCIA as the arbitral institution or nominate LCIA as the arbitral institution, then similar to ICC, LCIA also mandates the claimant to submit its request for arbitration along with its claim particulars and reliefs prayed for. So this is the list of requirements that need to be complied with. Similar to ICC rules, Article 2 of the LCIA rules, within a specified timeline, that is within 28 days of the commencement date or such lesser or greater period, the respondent shall deliver to the registrar a written response. So moment an arbitral notice is sent along with the claim particulars, the other side is given an opportunity to respond and provide its reply to the claim statement along with counterclaims, if any. So why I am skipping through all this is these set of particulars, if you compare, it would largely be the same set of particulars that are mentioned in ICC. So question may arise, okay, if the rules are largely similar, how do you designate just like what sir mentioned, it's a question of, you know, the cost angle, convenience angle, because they are situated in different parts of the world. So it's completely parties' prerogative to determine which would be the arbitral institution governing the arbitration process. So now we come to SIAC rules. So if you recall, I've covered ICC rules for commencement of arbitral process, then LCIA rules for commencement of arbitral process. Now I'm covering a third institutional arbitration called the SIAC, and what is the rules pertaining to invocation of arbitration under SIAC. So under Article 6, the claimant shall deliver a notice of arbitration, which is similar to our Section 21 notice, to the respondent, and the date on which the notice is received by the respondent shall be the date of commencement of arbitration. So similar to the ICC and LCI rules, when you furnish your notice to the other side as well as to the institution, that will be the date on which the arbitral process is commenced, and that again needs to contain all the following particulars, and one of them being a demand that the dispute be referred to arbitration, which is the obvious process, then a copy of description of the arbitration agreement invoked, a copy of the contract, a statement describing the nature and circumstances of dispute, and statement on existence of any third party funding agreement. So this is a very interesting component where you have third party funders coming in to fund certain high profile or expensive litigations. So you need to also clearly indicate as to whether this litigation is funded by a third party, because that's a necessary disclosure to be made during the process of adjudication, and payment of the claim filing fee, because each of these institutions have their own set of fees to be paid for. Now then you have your response to the notice. So once the notice invoking arbitration is made, naturally the other side gets to respond to the said notice, and this is again within a specified time period, and the response also needs to contain a lot of particulars, including your reply statement and counterclaims and reliefs prayed for. And one other thing that you can also consider in your reply is, in any of these institutions, you can also object or challenge to the arbitral tribunal's jurisdiction. It is not the case that if I choose to invoke the arbitration, you are bound by it no matter what. You could have an independent stance stating that, like sir mentioned on accepted matters, you could take a defense stating that the arbitration clause does not extend to the dispute so sought to be referred to arbitration, and accordingly in your reply you can furnish your objections to the commencement of arbitral process on the ground that the tribunal lacks jurisdiction to entertain the disputes which are sought to be referred by the parties. So with that, on commencement of arbitral processes, we have seen how the ICC rules work. Under section 21 of the 96 Act, you give a notice of arbitration. Under LCIA rules, articles 3 and 4. Under SIAC rules, articles 1 and 2. So point being, in all these 3-4 processes, the common thread is there should be a notice of arbitration which is served on the other side. The only difference, if you see, is under 96 Act, section 21 merely talks about delivering a notice of arbitration to the other side. That is in an ad hoc arbitration. Whereas in any of the institutional arbitrations, you would notice that when you submit a notice to arbitrate, along with the notice to arbitrate, you also submit your claim statement, and then the other side has to file their reply statement. In ad hoc, you submit a notice of arbitration, then a tribunal is constituted. The tribunal thereafter fixes the timeline for completion of pleadings. Only then the rest of the processes kick in. So I'll also explain the second process with the distinction in each of the various institutions process. The reason why I have chosen ICC, LCIA, SIAC is because these are the popular international institutions that parties typically nominate for conducting their arbitral proceedings. So these rules are very straightforward, and if you go through these rules, you will understand that in terms of the overall processes, like I had mentioned, they're all the same. The idea is at every stage, the other party needs to be kept informed of what is the current stage at which the arbitration is proceeding. And It's just very, very minor procedural differences in terms of each of these institutions' procedures. So now we can examine Constitution of Arbitral Tribunal. So parties under all the legal systems are free to decide the number of arbitrators, provided that the number is odd. So if you recall, Sir made a very valid point or important point that under uncitral model, if parties do not specify the number of arbitrators, then by default under Article 10 it's 3. Whereas under Section 10 of the Arbitration Act, if you don't specify the number of arbitrators, it's 1. And the whole point is cost effectiveness, as simple as that. So when you want to constitute an arbitral tribunal, you need to specify under the contract how many arbitrators are required to adjudicate the dispute between the parties. You can either nominate sole arbitrator or 3, depending on the nature of dispute, to be honest. But mostly, I've never come across an arbitral panel with more than 3. So I'm not sure if there are any typical international arbitrations, but possibly under BIT, Bilateral Investment Treaty, I'm given to understand it could be more than 3 as well. So yeah. So now we go to uncitral model law. Like I mentioned, Article 10 of the model law provides that parties are free to determine, and failing such determination, the number of arbitrators shall be 3. Why this process is important is, for you to have an arbitration process in force, you need to indicate how many arbitrators are required to adjudicate the dispute. So, which is why in each of these institutions, they have their own set of procedures on how an arbitral tribunal is constituted. So under the uncitral model law, typically if the agreement does not specify the number of arbitrators, the number of arbitrators would be 3. Whereas under the 96 Act, if you don't specify the number of arbitrators under Section 10, then the arbitral tribunal will consist of a sole arbitrator. Now we come to ICC rules. So even under ICC rules, Articles 11 to 13 deal with the appointment of the arbitral tribunal. Now, as per the rules, the dispute shall be decided by a sole or 3 arbitrators. So, in this institution, claimant shall nominate an arbitrator within 15 days from receipt of notification of the decision of the court, and the respondent shall nominate an arbitrator within 15 days. If the party fails to nominate, the appointment shall be made by the court. That is, both parties are given an option to nominate along with the request for arbitration and response to the request, and specify who their arbitrators are. And if they fail to do it, ultimately the court constituted under the International Commercial Court, they will determine the arbitrator to be appointed for the particular dispute. Court means the International Court of Arbitration established under Article 1 of the rules. So this is the designated court if you have an arbitration to be conducted by the ICC forum, then it is the International Court of Arbitration which is established specifically under Article 1 of the said rules, which would make the appointment. It is not the case that if you specify the arbitration to be conducted by ICC, you can approach any court of that particular state. You will have to necessarily approach International Court of Arbitration for the arbitrator to be appointed. And the court, again, this is not typical of other courts. This court's jurisdiction is limited for conducting the arbitral process alone, or rather overseeing the procedural aspects. The court does not substitute itself for the arbitrators to adjudicate the dispute. This court is contemplated by the ICC for the limited purpose of overseeing the arbitral process. So, like I said, the court does not itself resolve the dispute. It administers the resolution of disputes by the arbitral tribunal in accordance with the ICC rules. And where the parties have agreed that the dispute shall be resolved by a sole arbitrator, they may by agreement nominate the sole arbitrator for confirmation. And if the parties fail to nominate a sole arbitrator within 30 days from the date when the claimant's request for arbitration has been received, or within such additional time as may be allowed, the sole arbitrator shall be appointed by the court. Essentially, if both parties fail to nominate, then it is the International Court of Arbitration
which would confirm the appointment of the arbitrator, be it sole or 3-member panel, depending on the nature of the agreement. So it's not the institution itself, it is the court created under that particular institution which appoints the arbitrator, and this court is not typical like your other courts. It is created just for the limited purpose of overseeing the arbitral processes, like appointment of arbitral tribunal, for instance. And where it's by 3 arbitrators, then both parties get to nominate the respective arbitrators. The presiding arbitrator will be appointed by the International Court of Arbitration, and the third arbitrator will act as the president predominantly. So under the ICC rules, you will have to indicate whether it's a sole arbitrator or a 3-member panel, and once you choose your nomination, then the court confirms the appointment. But where you fail to nominate in case of 3-member panel or a sole arbitrator, then the court steps in and appoints the arbitral tribunal for conducting the dispute adjudication. So under LCIA rules, again very similar. Article 5 shall appoint the arbitral tribunal promptly following delivery to the registrar of the response. So even in LCIA, there is a court created for the limited purpose of overseeing the arbitral process, and this court is the London Court of International Arbitration. It is located in central London. So if you have your contract to be, or your arbitral processes to be conducted by the LCIA rules, then your appointment will be made by the London Court of International Arbitration, which is a special court created for, again, limited purpose of overseeing the arbitral process, and it is not going to enter into the realm of dispute adjudication. It is only for the limited purpose of procedural aspects. And these rules specify the qualifications for arbitrators as well. Each party shall give a brief written summary of his or her qualification. So in LCIA rules, before the London Court of International Arbitration goes ahead and appoints the arbitrator, the proposed nominee would have to submit their qualifications, their relationship with the parties, if any, their connection with the disputes, if any, before the court can actually step in and confirm the appointment. This again is to eliminate any possibilities of an partial or biased tribunal from being constituted. So as a prelude, the LCIA insists that whosoever is the nominee, they provide their qualifications and their disclosures well ahead of constituting the arbitral tribunal. Now in SIAC rules, again similar to LCIA and ICC, articles 19 to 23 deal with the appointment of arbitral tribunal. In terms of article 19, unless otherwise agreed, the tribunal shall comprise of 1 or 3 arbitrators. So depending on the nature of contract between the parties, you will see whether it's a singular tribunal or single sole arbitrator or a 3-member panel. And in the event that the parties have not agreed on the number of arbitrators, a sole arbitrator shall be appointed unless the registrar determines, after considering the views of the parties, that the dispute warrants appointment of 3 arbitrators. So in ICC and LCIA, if you see, there is a specific court created for the limited purpose of overseeing the procedural aspects, including appointment of arbitral tribunal. Even in SIAC, it is the registrar or the SIAC court, both being interchangeable, which will constitute the arbitral tribunal. Where parties fail to nominate or where parties fail to agree upon the number of arbitrators, then it's the said institution which will appoint the arbitral tribunal. And typically in all these institutions, if you see, they will have a list of empaneled arbitrators, and they would accordingly choose from the said empaneled arbitrators. Whereas in ad hoc, like sir indicated, you can choose to nominate a specific person well ahead in contract, although that's not advisable, or both parties can agree upon any individual to be appointed as the arbitrator. So even in SIAC rules, the procedures are largely similar, where if both parties fail to nominate, then it's a particular institution which goes ahead with the appointment of the arbitral tribunal. So in each of these processes, because I'm kind of running short of time, so all the comparative procedures under each of these institutions are contained in the PPTs. But what I would like to mention is, in each of these processes, the procedures are largely the same, and it's very, very, very small differences in terms of how the procedures are followed. For example, in the two sets of processes that we followed, we saw that in a ICC and LCIA, when it comes to constituting the arbitral tribunal, there is a specific code created to appoint the arbitral tribunal, whereas in SIAC, it's the registrar who appoints the arbitral tribunal. And similarly, for notice invoking the arbitration, under the ad hoc arbitration under section 21, you simply issue a notice of arbitration, then a tribunal is constituted and timelines are framed. Whereas if you follow any of these institutions for your international arbitration, they mandate that along with your notice of arbitration, you also submit your claim statement, and other side, when they submit their reply, it also contains the reply statement and counterclaims. And only after the pleadings are completed and all the documents are collated, the institution goes about appointing the tribunal, and the tribunal would commence the hearings directly. So that is hugely time efficient and time saving, and the tribunal need not waste its efforts and resources in terms of completing the proceedings on at least until the pleading stage. So that is the biggest advantage of relying upon institutional arbitration, because the entire process of pleadings, framing of issues, etc. are done before the tribunal even commences their first hearing. When the tribunal sits, it's for the limited purpose of oral arguments, conducting of trial, and passing of award. So I will go back to my slide on where I had discussed the various processes. Sir, 1 second, can you just, so that I can give you a bird's eye view of what are all the various processes involved. Then I can go on about explaining each of the institutions' procedures. So in this slide, if you see, I have given a bird's eye view of the entire process. So we had seen the nature of international conventions, that is your New York Convention and Montevideo Convention and your Geneva Convention, and your model law, which is your UNCITRAL model law, and the laws applicable to international commercial arbitration, which is your 3 cardinal rules, that is law governing the arbitration agreement, law governing the contract, law governing the seat, especially in instances where the law governing the arbitration agreement is not specified. Then your arbitration agreement, how it needs to be in writing, and how the parties have to clearly communicate their intent to arbitrate the dispute between the parties. And this is the important one. So the remaining portion of my slides largely cover the 4th point, that is the various arbitral processes under each of the international institutions that oversee the conduct of arbitration. So commencement, so we have now seen commencement and constitution of arbitral tribunal, that is from your notice invocation stage to appointment of the tribunal. The next step, it's not exactly in sequence, but largely these are the steps involved. So the next step is, let's say an instance where the tribunal is constituted, but either of the parties have certain objections in relation to the independence or impartiality of the arbitrator. Then what is the challenge process to be considered? Under the Arbitration and Conciliation Act 96, you have sections 12 to 14, which lay down the framework for challenging the appointment of arbitrators. So similarly, in each of these institutions, you are not left remediless. You can very well challenge the tribunal members appointed by the said institution if certain facts come to light that the appointment, although done by the institution, is still not independent or impartial. So you very well have the grounds to challenge them, and I have captured all the relevant rules that provide for challenging the appointment process as well. Then you have substitution of arbitrators. This step, essentially, let's take a scenario where the particular arbitrator is unwell or not in a position to continue. Again, you cannot be left remediless. So similar to the 96 Act, each of these institutions provide a specific procedural component to be followed for you to have a particular arbitrator, sole arbitrator, or in case of a 3-member panel, any specific arbitrator, to be substituted. Point number 5 is jurisdiction of arbitral tribunal. This is very important. Like I said, when you submit your claim to arbitration and the other side qualifies the said dispute to fall within accepted matters or takes a defense that the particular dispute is non-arbitrable, then you have the possibility of challenging the jurisdiction of the said arbitral tribunal from conducting the arbitral proceedings. Then you have your conduct of arbitral process, your interim measures, emergency arbitrator. Yes, this is very important because if you recall, even Sir had mentioned it in his previous session. Emergency arbitrator, if you guys had seen the news a year ago, Amazon and future dispute largely revolved around the enforceability of an award passed by an emergency arbitrator. So I'll just quickly give a small background. In the Amazon future dispute, it was the SIAC arbitral tribunal which was nominated for conducting the arbitral proceeding, and SIAC rules provide for possibility of passing of an emergency award. Emergency award in the sense you have your interim measures typically that you can approach the court under section 9 to protect the subject matter of arbitration. SIAC rules also go a step further and provide for the possibility of creating an emergency award where the situations warrant some immediacy for the purpose of protecting the parties' rights. And in Amazon future dispute case, they had invoked this rule under the SIAC rules for the passing of an emergency award, and Amazon had an award in its favor where the arbitrator had I think directed future to pay X number of sum or maybe not terminate the contract if I'm not wrong. So they had passed a limited emergency award, which is an award passed before the constitution of tribunal. Future, then once Amazon got an award in its favor, it sought to enforce the award in India before the Delhi High Court. So going back to the original explanation, Amazon was in a position to do that because India and Singapore are reciprocating countries. So Amazon sought to enforce this emergency award under section 17, stating that this award that I have got against future ought to be recognized. Then future took a stance stating that the Indian Arbitration Act does not recognize the possibility of the emergency arbitrator on an emergency award, and therefore the said award cannot be binding. The matter went up to Supreme Court. Ultimately, Supreme Court held that emergency award is also contemplated under the definition of the definitions contained under the Arbitration and Conciliation Act, and consequently the said award is very much enforceable in India. So emergency award, at least from an Indian perspective, came to limelight through the Amazon future dispute, and each of these institutions actually contains specific rules for the purposes of creating a interim arbitral tribunal just for the limited purpose of passing of the emergency award. There are very stringent timelines which provide for the passing of this award in a very very small set of time frame, because ultimately you have your main disputes to be adjudicated by the tribunal composed at a later stage. Prior to that, if you want your rights protected, these institutions provide for passing of an emergency award, which is what happened in the Amazon future dispute. Then lastly, you have termination of proceedings, how it differs from each of these institutions, and typically the passing of award by itself would render termination of proceedings. And in each of these cases, there could be instances where a claimant chooses not to pursue, and then that could also qualify as a termination of proceedings. So each of these institutions contains specific rules with respect to when a proceeding is deemed to be coming to an end. Then you have your interim reliefs by court and enforcement of awards, which is very important, like I said, because this goes, at least from the Indian perspective, goes to the part 2 of the Arbitration Act. That is, the two factors that you need to necessarily look into is whether the state in which the award is passed is a signatory to the New York Convention for India to recognize it. Secondly, whether the state in which the award is passed is a reciprocating territory of India, so that you can successfully enforce the award in India. So I'll just read out section 48 of the Arbitration Act. So section 48 talks about condition for enforcement of foreign awards. Enforcement of a foreign award may be refused at the request of the party against whom it is invoked only if that party furnishes to the court proof that the parties are under some incapacity, the parties against whom the award is invoked was not given proper notice. So proper notice is a very, very fundamental aspect for you to have an award to be deemed as a valid award. 3, the award deals with a difference not contemplated or falling within the terms of reference. This is again a very important aspect because not only do you have the right to challenge the jurisdiction, you can very well have the award not enforced if it's clearly demonstrated that the terms of reference or the basis on which the award was passed does not fall within the ambit of the arbitration agreement. Then the composition of arbitral authority or the arbitral procedure was not in accordance with the agreement. The award has not yet become binding on the parties or has been set aside or suspended by a competent authority of the country in which or under the law of which the award was made. So if the composition of the arbitral tribunal was not made in accordance with the rule, then the award so passed by the said tribunal cannot be enforced. Then lastly, if the award was not binding because the award passed in that particular contracting state was set aside by the competent court in that state. Now let's say the award was passed in Singapore and the law governing the seat is Singapore law. So an Indian party and a Singaporean party decides to designate Singapore as the seat and an award is passed in Singapore in favor of the Indian party. Now the question is whether the Indian party can enforce the foreign award. Answer is yes, it can, because Singapore is a reciprocal entity and Singapore is a New York Convention signatory as well. But the factor that the court will consider before enforcing the award is, one of the factors rather is, if that award passed in Singapore was ultimately set aside by the courts in Singapore, then the said award has not attained finality and consequently it cannot be enforced by any Indian court. So section 48 enlists the various grounds that the court needs to consider while enforcing an foreign award which is passed outside India. So in terms of international arbitration process, these processes are largely similar to that of a domestic process as well, with differences in relation to, let's say, emergency award. That is something which is not recognized in the conduct of a domestic arbitration process, and sometimes how the tribunal is constituted, there are significant differences between each arbitral institution. So you have these minor differences with each of these processes between domestic and arbitration process, domestic and international process, but largely if you see, the processes remain the same because you typically have to commence the arbitration process through the notice of arbitration, composing the arbitral tribunal, ensuring that the arbitral tribunal is independent and impartial. The tribunal then gives a chance to both the parties to present their case, then examine the witnesses, then lead oral evidence, submit their written submissions, and then pass the award. So the principles, or at least the overarching processes, remain largely the same, with just minor differences in the institution that you choose to designate for conducting the arbitration process. And secondly, in international arbitration processes, the three cardinal principles are extremely key for you to keep in mind while drafting the arbitration clause, because you need to be very specific about indicating the law governing the contract, law governing the seat, and law governing the arbitration agreement as well. So that would determine how the arbitral tribunal would decide based on which law to apply, and ultimately if the award is passed, whether the said award can be enforced, because it would all depend on whether they are signatories to the particular Geneva or New York Convention. And from India, like I said, it's a reciprocating territory, but other countries have different thresholds. But the signatories have to necessarily ratify the convention under their domestic laws. So each time you draft the arbitration clause, just be careful and don't just choose based on the superiority of a particular institution. Be very mindful of whether the award can be enforced, because that is ultimately the crux of why you would even want to pursue the arbitration. So this is on the international arbitration process. To be honest, there is a lot more intricacies to be covered, but in the short time frame, I've tried to condense the entirety of process by comparing it with each of the institutions. But there is a lot more information on each of these institution rules, how the process works, and I've also dropped in few important case laws for better understanding. So please do go through the slides and feel free to reach out in case of any clarification. Now coming to the second topic, which is, to be honest, very open-ended topic in terms of what are the opportunities available for professionals. So as you know, in terms of opportunities, if you ask me, there is nothing specifically under the Arbitration Act that prohibits professionals from entering the realm of being appointed as the arbitrator, because it is ultimately governed by the party autonomy to choose whom they want to be bound by. So in construction contract, for example, you have engineers being appointed as arbitrators because they have a better sense of understanding. So since a bunch of you are chartered accountants, let's say if it's a dispute pertaining to valuation of shares and parties enter into a contract in relation to that very specific component, 100% professionals who are well versed with the accounting side of things can be appointed as arbitrators. So I'm just giving a very basic instance of one possibility being appointed as an arbitrator, which would be subject to the party consenting to it. So each of these institutions also have a specific set of rules and framework that you need to follow for you to be appointed as an arbitrator. So arbitrator is one such possibility. One more possibility is, so in section 20, one second, section 27, which is titled Court Assistance in Taking Evidence. So during the arbitral process, there could arise a situation where there, let's say it's a typical dispute between company A and company B, and ultimately the dispute has certain components of forensic audit or some statutory audit not being conducted rightly. The tribunal is empowered to take assistance by appointing an expert, and expert is where the chartered accountants can come into force by rendering their assistance to the tribunal or the advocates who or the parties whosoever are there to give their expert opinion on whether the queries posed to them are right or wrong. So this expert evidence actually has a very big evidentiary value, because this opinion rendered by the expert would ultimately be factored into the passing of the award. So one other factor is court taking assistance of an expert, and experts could be assisting the tribunal in terms of the queries posed to them. And lastly, what I've noticed is while arbitrators or expert evidence are two possible factors, there is a significant dearth in contract management. That is something from my limited experience I've seen that is given a complete go by parties. So parties do not understand that it's not enough if you just jump to arbitration and constitute the tribunal and have the hearings conducted. You need to lay the basic foundation for the disputes to be adjudicated successfully, and that is where contract management comes in, because each communication and correspondence addressed with the other side has to be carefully vetted in terms of the contractual obligations to see if they are in compliance with your rights, or if you feel there is a drawback, you don't expressly admit to your rights and obligations. So this is something that can be undertaken by any individual, because the legal component is mostly limited, which you can always liaise with a lawyer or any other counsel of the choice. But in terms of drafting and ensuring each of these correspondences are in compliance and you don't make any false admission, and you always have the last say before the dispute enters into arbitration. So contract management is a very niche and a rather field that has been neglected, because that forms a huge value in terms of laying the groundwork for the arbitration to be completed successfully in favor of the party whomsoever you respond. A lot of parties, from what I've seen, they fail to respond to the last reply from them, and that is usually argued by the other side that since they didn't respond through conduct, they have admitted to what I've stated. So each of these steps are very, very important, and as professionals, very well entitled to render contract management services as an avenue that could be brought within the arbitration field. In my opinion, that's a very, very important field, because only when you ensure that your communications are intact will they form a good evidentiary value during the arbitration process. So these are the three possible avenues that I could think of for professionals to engage with the arbitration sphere. So with that, I think I complete my presentation for today. My apologies, it's actually a lot more, like I said, but in this limited time frame, I was able to complete so much. So in case of any further queries, let me know. And any other queries or questions? Fine.
So thank you so much, sir, for a wonderful session. It was not only informative but made a clear understanding of the law, sir. It was very good. Okay. I would like to welcome our third chief guest, Advocate Subhang P. Nair, to the stage, sir. Thank you. To have a short summary of him, he is an advocate with a decade of experience in litigations. He is also currently practicing in Madras High Court and also appeared in court across country, including Supreme Court, various High Courts and various tribunals. As a graduate of prestigious National Law School of India, India University, Bangalore, he has worked with various leading firms and renowned senior counsels specializing in litigation, arbitration and corporate legal advisory. He has an impressive clientele which includes IDBI Bank, L&T Limited, Zoho Corp, Shastra University, TVS Motors, Wipro, Xiaomi Technology and Mass Klein AS. I welcome you to the... before that, I would like to invite CA Bashir sir to give away the momentum as an honor to the guest. Thank you, sir. Yeah, I would like to invite Subhang Nair to present this.
So thank you everyone, first of all. I mean, it's a post-lunch session, and though there have been two very informative lectures already, to everyone I'm sure is a little bit sleepy, at least at this point. So I hope I can keep it engaging by sort of making this more of a discussion than a lecture with everyone here. So just like Sriram had said before me, if you have any questions at any point, just feel free to let me know. Just put your hands up. I could stop the presentation midway, and I would like to take the questions. And sorry, yeah, I'm not very comfortable with this sort of mic system yet. And in addition to that, so basically coming to my scope of presentation today, it's on the key legal precedents in arbitration law. Now, primarily that will involve going into the judgments of the Supreme Court and the various high courts in our country, at least. In addition to that, I would also like to try and interpret legal precedents to also include
So, in addition to the judgments, I would also like to try and venture to see how you could draft an arbitration agreement as well. Because when I was interacting with some of you during lunch, at least, what was indicated was that it would also help in terms of a practical benefit for chartered accountants who typically, when you're interacting with your clients, etc., you are more peacetime advisors, litigating lawyers, etc. They come in during wartime. I mean, it's during peacetime, clients primarily look towards their chartered accountants and their internal company secretaries to be giving them advice as to their documentation, etc. And when it comes to giving advice like that, it's useful, amongst other things, to also be familiar with the framing of an arbitration agreement in their contracts. So, coming to what I would try to cover, I'm basically looking at the presentation as having maybe three objectives. One, to deal with the the CPE angle of it, which is to sort of give you an introduction or give you some sort of information about a tangential field of activity, that is arbitration, to your own field of activity. Secondly, from a practical standpoint, where you come across an arbitration scenario, whether it is you're functioning as arbitrators or whether you're functioning as an advisor to one of the parties involved in the arbitration, or there may be a scenario where Sriram already mentioned certain cases where there are career opportunities. I think he had given three situations which are pretty exhaustive. One additional situation which I've also come across in my limited experience is of having chartered accountants or cost accountants as being claim consultants. So this is something which is coming up in India right now, where chartered accountants or cost accountants, because of your expertise, especially in forensic accounting, etc., when there is a breach of contract, it's typically done in larger construction contracts. When there is a breach of contract, the contractor, let us say if the case which I came across was a dispute between a large engineering corporation and the government of Tamil Nadu, where for a highway laying project, the government had cancelled one portion of the contract, and the contracting party, the contractor, had suffered major losses. So to determine the true, because it had a revenue impact on their annual performance itself. So to determine the impact of the breach caused by the government in that case, they had engaged a chartered accountant, one Mr. Krishnan, to act as the claim consultant. So he would quantify the damages by using forensic auditing to say that as a consequence of these breaches by the government or the termination of this contract, this is the impact that it had on the balance sheet. And that, I think, a CA is much better placed to put across to an arbitrator than any lawyer. So that is also one up and coming thing. It's not very prevalent right now, but we hope that in the future we have the benefit of having claim consultants who are chartered accountants who can draw, let's say, who can shed light on the financial aspects of a dispute. Similarly, I think he'd given the example, there is also, we had one ongoing partnership dispute which is regarding the splitting up of a partnership, where we've been struggling. We've had a very eminent legal person as the arbitrator, but we've been struggling for a while because the accounting aspects are very difficult for him to grapple with because he doesn't have an accounting background. So at the end of the day, now we've taken the expert assistance of an chartered accountant to do the valuation and to do the division of the assets of the firm as well. So that way there are quite a few opportunities. So it is beneficial for chartered accountants to also be familiar, if not comfortable with the arbitration law in our country. Now, that's the second objective, to sort of give a practical benefit in terms of introducing you to arbitration law. Now, coming to what I'd seek to cover, first, I would like to cover the formation of arbitration agreements, though both the speakers before me have very elaborately explained as to what should be the essential requisites of an arbitration agreement, etc. What are the ingredients of an arbitration agreement. I'll maybe therefore to go into it in some more depth, I'll try and do an exercise. I hope that's permissible, that I can do an exercise to sort of draft your typical arbitration clause. Like if you're drafting a simple arbitration clause for in an Indian domestic arbitration context, how you may go about that, or what you should be looking for if you come across a typical arbitration clause. So that would be one aspect regarding the formation of the arbitration agreements. In that, while doing the simple clause, we will also discuss on certain principles that apply to arbitration clauses, like incorporation by reference principles. I think Inbavijayan sir had discussed about standard form contracts and how when there are government standard form contracts, there is no leeway which is allowed. Quite often what happens is also that many companies have general conditions of contract, etc., which will contain the arbitration clauses. Those are incorporated by reference into each of their purchase orders, each of their smaller work orders, etc. How that incorporation by principle applies in the context of arbitration agreements is the second aspect that I'll be looking to deal with. The third will be on two-tier arbitration clauses and on multi-tier dispute resolution clauses. Now, those typically work in two ways. Two-tier arbitration clauses, they are rarer. Typically, how it works is that there would be the first tier of arbitration where the parties agree that, let us say, X person will function as the arbitrator and adjudicate upon disputes that arise between us. If either party is dissatisfied with the decision taken by X party, we will go to either Y or a tribunal of maybe 3 persons to make an appellate decision on that. So those types of arbitration clauses also exist where you have multiple tiers of arbitration. One place where this is fairly commonplace is in the context of, again, construction contracts, where the first dispute resolution tier will be by an adjudicator who might even be an employee or an independent engineer who is engaged by the owner or the, let's say, the government employer in that case. And if either party is dissatisfied with the decision of the independent engineer, they could then go to an arbitrator who might be appointed by the court or by any other institution in the country. So those are two-tier arbitration clauses. The last is also multi-tier dispute resolution clauses. In multi-tier dispute resolution clauses, sometimes parties may not want to right away jump into arbitration. So before they go for arbitration, they might want to either try mediation or conciliation, some sort of negotiation between themselves so that they can mutually resolve the dispute. They might say that if a dispute arises, we will first try this for 30 days or any time period which they can mutually agree upon, failing which we will then go for an arbitration. So there can also be those sorts of multi-tier dispute resolution clauses where parties opt for mediation followed by arbitration. So the first portion of my presentation will briefly deal with each of these types of cases along with judicial precedents which have considered all of these cases. The second portion of my presentation will be regarding judicial precedents in the context of at the reference stage, which is the appointment stage as had been spoken about by Mr. Inbavijayan, where either the High Court or an institutional arbitration forum appoints an arbitrator. What are the tests or what are the factors that they would be looking at? And what are the types of, in our language, what would be the scope of judicial review at that stage of the process? So that is the pre-arbitration stage. Then we will go on to the arbitration stage, which is where, let us say, if you are functioning as an arbitrator, typically what are the challenges which would be put to you both at a preliminary stage in terms of, the speakers before me had spoken about this to some extent as to the jurisdictional challenges which can come, the challenges regarding conflict of interest of an arbitrator that can be raised, precedents, judicial decisions which deal with some of these aspects, and what are the decisions with regard to arbitrability. Mr. Inbavijayan had dealt about this, about how he had taken the example of rent control matters as to why they are not arbitrable because there is a statute which specifically prohibits or implicitly prohibits arbitration. We'll be looking at some of these subject matters which are not or which cannot fall within the scope of an arbitration and why they are kept outside the scope of arbitration. Now, and that is something which I hope I'll be able to do throughout this presentation, is to also address the why or the underlying logic behind some of these rules. What the arbitration process is and what arbitration agreements are have been elaborately explained to you. I think I'll have very little to add to that. My endeavor here will be to sort of try and explain as to why are those things the way they are. So, carrying on from that, apart from preliminary issues which may arise with regard to conflict of interest in jurisdiction, the last part would be the arbitrator preparing an award itself. When you are functioning as an arbitrator, when you're determining the rights of parties, the predominant portion of work, definitely, like Mr. Inbavijayan said, is very factual. You'll be looking at the factual dispute between the parties and deciding who is wrong and who is right within the overall legal matrix. But beyond that, there may be a few legal principles which might be useful for any arbitrator to know, particularly with respect to how do you, most arbitrations typically involve monetary claims. They may be money disputes, as we call them. So while deciding what the damages or what the losses or compensation would be, which would be awarded to either party would be, it is also useful to keep in mind certain principles which might apply to all such cases. So, and lastly, I'll briefly also be dealing with what the scope of challenge for an arbitral award would be before a court, only insofar as to help illustrate as to what are the do's and don'ts when it comes to writing an arbitral award, as to what should be sort of avoided when you're writing an arbitral award and what would be the, let's say, the minefields that you to sort of try and stay away from. Now, coming to the first portion on arbitration agreements. Now, the speakers before me had already dealt with how the arbitration agreements are defined under the Act. As I had said, Section 7.1 defines an arbitration agreement to mean an arbitration agreement is an agreement by the parties to submit all or certain disputes. this is why Mr. Inbavijayan had said that typically it starts with saying all disputes or any disputes, because parties also have the option to refer only certain disputes between them to arbitration. So it either all or certain disputes which have arisen or which may arise. So either in the past which have, so after the disputes have arisen, parties can enter into an arbitration agreement agreeing that we will go for an arbitration because maybe a court will take too long to decide on this dispute. Or at the time of entering into the contract itself, parties might decide that any dispute that arises between us in the future, we will refer to arbitration. Then which may or may arise between them in respect of a defined legal relationship, whether contractual or not. So that again, there should be a defined legal relationship between the parties. I'm sorry, is the mic too loud? Is it okay? It's a defined contract legal relationship, whether it can be a contractual relationship or not. In fact, there's a developing this thing as to how even disputes which are non-contractual can be referred to arbitration. For instance, intellectual property disputes, where there are cases of copyright infringement, etc. If parties agree and if there is no dispute with regard to the ownership of the intellectual property, because then it becomes an action in rem. We'll come to that portion later. But where there is no contractual disputes between the parties also, there may be scenarios like intellectual property infringement disputes where parties can agree to refer it to arbitration if they are actions in personam. What this actions in personam and actions in rem are, we'll just come to in the later part of this presentation. Now, coming to in terms of legal precedents, the main judgment in this regard, the locus classicus as we say, is this judgment called KK Modi versus KN Modi, which arose from a family dispute inside a business family, from which there was a question as to whether the agreement between the families, which was an informal agreement, whether it had all the requisites of an arbitration agreement. So the Supreme Court in that case, in addition to what was already held, what was already contained in the language of Section 7, the Supreme Court held that the agreement must contain it must contemplate that the arbitrator can give a binding decision to the parties. That is, if the agreement is not clear that the decision of the arbitrator will be final and binding, then it becomes insufficient, because then the reference may not be the other party or the losing party has the scope of challenging it, saying that it was never agreed between us that this was a binding arbitration decision. It was only in the nature of an opinion which we wanted to seek from this third party. So the Supreme Court was clear that the agreement should require that it is a binding decision and it should determine substantive rights of parties. That is, therefore, there should be a clear dispute, and the rights of the parties vis-a-vis the dispute should be determined by the arbitrator. Now, before I go on to unilateral appointment, as I said, one exercise perhaps is to try and frame an arbitration agreement as to what is the essential language that any of us would use when we are framing an arbitration agreement. Now, in this regard, the first score, as we've said, from Section 7 and from KK Modi versus KN Modi, the first, let's say, the scope of the language that we need to do is to be clear on what disputes are you referring to arbitration. Is it any of the disputes? Is it all of the disputes that may arise between the parties? Or is it certain disputes? Most contracts which we come across, typically when the contracting parties enter into those contracts, they say all disputes that have arisen within the contract. This is typically the easy part. So the first portion would sort of be that all disputes or any disputes. So this would typically mean it's a more wide-ranging arbitration clause where any and all disputes that arise between the parties can be referred to arbitration. The next portion of the clause is where it gets a little more complicated, because once you say in a contract all disputes, you would typically you would use the language to say all disputes under this agreement or all disputes arising out of this agreement could be referred to arbitration. There, the Supreme Court has in the past, it has resulted in complications, because what happens, especially in larger contracts, is that sometimes there might be an addendum agreement, sometimes there may be a variation contract, in relation to which what might happen is that there may be some disputes where claims arise both under the addendum agreement and the main contract. In those cases, defendants have taken objections to state that when you say all disputes arising under this agreement, it only means the main contract and it does not cover the addendum agreements. So in those cases, it leaves open the opportunity for a dishonest party to take a technical objection to avoid the arbitration, because once certain claims fall outside the scope of the arbitration agreement, they could argue that the entirety of the dispute should fall outside the scope of the arbitration. So then the language which was evolved in reaction to that was to say all disputes arising out of or in relation to or in connection with. Now, out of these three phrases, any of them or in many contracts, all of them are used to sort of show that it is not just disputes under this agreement, it is disputes in relation to, in connection with, or arising out of. Arising out of this agreement. So by the Supreme Court in judgments like MR Engineers, which we'll be coming to subsequently, has held that these are the broadest language that can be used, and this indicates that the parties, because the courts generally tend to take a pro-arbitration stance. So if the intent of the parties can be gathered from this language, the court then says that almost any dispute then arises, whether it is directly under that agreement, or it might be, like I said, from an addendum or from another work order which is in relation to the same work. Even those disputes, it has been held, should be referred to the arbitration. So the second portion of this becomes arising out of or in connection with. So arising out of is not wide enough. Ideally, the language to be used would be in connection with or in relation to. So that would be the second portion of the arbitration clause, where you say any disputes or all disputes arising out of or in connection with this agreement shall be referred to arbitration. There again, there is an important slight legal distinction. It is always ideal to use shall be referred as opposed to may be referred or would be referred, because though may or would indicate an option being available to the parties. So may be referred would indicate that parties may, they may not also. Typically in legal language, if you want to bind a party, it is always ideal to use shall, and therefore most well-drafted arbitration agreements will use any disputes arising out of or in connection with this agreement shall be referred to arbitration. Now, once that much is clear, then it is clear that the parties intend to refer the parties to arbitration. Then we come to the aspect of the three laws which Sriram had discussed. So then it comes to parties want to go for arbitration. How should the arbitration be conducted? So the what is clear. It should, parties have agreed that they should go for arbitration. Then coming to the how should the arbitration be conducted? Typically the agreement would then say, would be referred to arbitration to be conducted by a sole arbitrator or a panel of three arbitrators. Now, it's already been explained, either cost effectiveness or for reasons of ensuring that both parties have an equal say in the arbitration, we may go for one arbitrator or three arbitrators. In those scenarios, so it will say, let us take a case of it being a sole member arbitration tribunal. That will say that any disputes that are arising out of or in connection with the contract shall be referred to arbitration by a sole arbitrator to be appointed by either, it cannot be to be appointed by either of the parties, as Mr. Inbavijayan had said, because of the judgment in Perkins Eastman, which we will come to next, and a subsequent Supreme Court judgment of a larger bench. It is now the law in India is settled that a unilateral appointment by a party cannot be done because of the equality principle, which is that both parties should have equal say in the appointment of an arbitrator. Or it should be done by a completely neutral forum, like let's say a high court or a institutional center. So where it comes to, it can be typically it can be an institution, it can be the high court or the Supreme Court, as the case may be, or it can also be a third party individual. It is not that parties are prohibited by law from having, let us say, a senior chartered accountant be the person who will be the appointing authority for that arbitration clause. So parties can agree for any dispute that arise between us. So and so senior chartered accountant would be the appointing authority for the arbitrator. The only requirement in those cases is that person should have independence from both of these parties. He should not be somebody who is in a position of conflict with either of the parties. As long as that is the case, even a trusted third party individual can be trusted with the mandate of appointing an arbitrator. So it would say, shall be referred to arbitration under the Arbitration and Conciliation Act 1996 to be appointed by, let's say for ease of reference, by the High Court of Madras. After that, typically the next line would be defining the seat of the arbitration, what Sriram had spoken about. When you're defining the seat of the arbitration, it also means in a domestic arbitration context, we are defining where would a challenge to the arbitral award lie. So either party, once the arbitration process is complete and the award is passed, if they want to challenge the arbitral award, which court would that challenge go before is determined by where the seat of the arbitration would be. So let us say in this case, if we say that the seat of the arbitration will be Chennai, then as the Madras High Court has original site jurisdiction as well, if it is a dispute above 1 crore, then the High Court will be the forum before which the challenge would go. So if there is a Section 34 petition to be filed challenging the arbitral award, it will lie before the Madras High Court. Similarly, if let us say the seat of arbitration is Coimbatore, then it would be the district court in Coimbatore before which the Section 34 challenge would lie. So it is very important from a holistic standpoint for parties to very clearly define in their agreement as to where the seat of arbitration would be. And this can be done in one of two ways, either by very clearly stating that the seat of arbitration is Chennai or shall be Chennai or Coimbatore. In addition to that, as abundant caution, what parties also do is saying that this arbitration agreement shall be subject to the jurisdiction of the courts in Chennai or the courts in Coimbatore or the courts of competent jurisdiction in Chennai. So that is sort of a measure of abundant caution whereby you are making it very clear that yes, the seat is here. So typically this would be the law which is governing the arbitration agreement. In addition to that, you're also putting it in express terms saying that the courts of this jurisdiction shall govern the arbitration agreement. Now, if you were to opt for an institutional forum, because let us say for whatever reasons the parties feel that an institutional arbitration will give them the benefit of having a very well-defined procedure, that it will not be left to the whims of one individual, rather it will be one defined institution's procedure that will be followed. In those cases, in addition to this, then a line can be added to say that the procedure or the conduct of the arbitration proceedings shall be governed by the rules of the so-and-so center. So it shall be either the conduct of the arbitration proceedings shall be governed by the rules of the Madras High Court Arbitration Center or the Nani Palkiwala Arbitration Center or the Sikhi Arbitration Center, etc. To take the examples in Chennai, that is. So there, what you're ensuring is to basically assuring yourself that there is a well-defined system of rules which will govern the procedure of the arbitration. Alternatively, even if this is not spelled out in the contract, parties do not substantially are not substantially prejudiced, because ultimately, even if the procedural law is not defined in the contract, the Arbitration Act is very clear that the principles of the Code of Civil Procedure should apply. So even for an ad hoc arbitration where it is an individual arbitrator who is appointed, that individual arbitrator is still bound to follow the principles laid down in the Code of Civil Procedure. Now, they're not very complicated principles either, because all that is required to be done is to ensure that both parties have an equal opportunity of participation, that if there is a witness, there is also an opportunity to cross-examine the witness, etc. It's fairly spelled out in the Arbitration Act itself. So either an ad hoc procedural rule can be opted for, or parties may opt for an institutional rule by specifying this. And in addition to this, the only other language that is typically found in an arbitration agreement would be to say that the language of the proceeding shall be English or Tamil, as the parties may prefer. And in addition to that, to finally, again, to bring ourselves back to KN Modi, is to say that any decision by the arbitral tribunal shall be shall be final and binding upon the parties. So that last sentence is important to ensure that it has all those quality marks of an arbitration. Yes, and that's about all the essentials of a basic arbitration agreement. where it comes to a single member, single tier arbitration clause. In addition to this, what parties also do is there will also be, to be clear on what the law governing the contract will be, there will be a separate clause on governing law and jurisdiction, which will again say that the rest of the contract, apart from the arbitration agreement, the contract shall be governed by so and so law and shall be subject to the jurisdiction of courts in Chennai or whichever forum that the parties may prefer. So typically these are the hallmarks of an arbitration agreement. Now coming back to the portion regarding the unilateral appointment of an arbitrator, it has been since Perkins-Eastman, there has been some debate on this issue of whether a party can unilaterally appoint an arbitrator, because right after Perkins-Eastman, the Supreme Court in another judgment called the core judgment, basically the Central Organization for Railway Electrification judgment, it held that in several cases government PSUs especially usually have a panel of arbitrators, and they insist in those arbitration clauses that one of those arbitrators should be appointed. By virtue of the Perkins-Eastman judgment, these clauses came to be challenged, because contracting parties started raising an objection saying that this is also unilateral appointment. The government is basically forcing upon me an arbitrator who I do not want, and all the people in the panel might be loyal to the government in some way, or they are beholden to the government in some way, and therefore we are objecting to these arbitrators being appointed on the basis of the Perkins-Eastman judgment. Initially, a two-judge bench of the Supreme Court took a view that these panel appointments are valid, which was then disagreed by another two-judge bench of the Supreme Court in Tantia Construction, and it went up to a larger bench, which is that very complicated name, but it's basically Central Organization for Rural Electrification versus Southwestern Railways. In November 2024, the judgment came out, which emphasized on the equality principle, which is basically that the fundamental principles for an arbitration are one, party autonomy, which is that both contracting parties should decide how and in what manner their dispute should be adjudicated upon. The second is the equality principle, which is sort of an exception to party autonomy. So although parties can decide how and in what manner their disputes are adjudicated upon, one core principle that has to be adhered to is to ensure that both parties have equal opportunity of participation in the arbitration. So whether it is in the appointment of the arbitrator, whether it is in the filing of their pleadings or the manner in which they give evidence before the arbitrator or how they argue before the arbitrator, both parties should have equal opportunity. That is, it is not that if one party says that so and so will be the arbitrator, the other party will be bound to accept it. So the Supreme Court held that even if there are panels which the government maintains, and they held that the governmental authorities are free to maintain such panels, but it will not be binding on the other party. The other party can reject all the members in the panel and also seek an appointment for another independent arbitrator to be appointed. So this equality principle now remains one of the main fulcrums of any arbitrator appointment, where it is ensured that there is a fair appointment of an arbitrator. Apart from that, the next portion would be with regard to the procedural equality in arbitrations, which is that whether it is in evidence, etc. For example, it cannot be that only one party is given the right to cross-examine and not the other party for their witnesses. So in every step of the arbitration process, if one party is given an opportunity, let us say one party is given an opportunity to file additional documents in an arbitration after the evidence is closed, the other party should also be given the same opportunity to lead rebuttal evidence by filing any additional documents that they may need to file to that. So that principle now has come to form one of the fundamentals of an arbitration. And the last exception to that, so the equality principle itself is an exception to party autonomy. To that equality principle, the exception is the necessity principle, which is sort of enshrined in section 12(5)'s proviso, which basically says if the party was aware of an issue of conflict of interest or other conflict that existed for an arbitrator, and if they chose to still participate in the arbitration proceedings and not raise that issue, then they are deemed to have waived that right of objection which they had. So they can no longer raise that as an objection to challenge their arbitral award, which is finally passed between the parties. So now coming to the next portion on arbitration agreements. Now, while we've dealt with the basic format or basic structure for an arbitration agreement in a single member arbitration context, the next portion would be to deal with slightly more complicated agreements which we discussed earlier. The first one in MR Engineers was with the first relevant judicial precedent in that regard was, and all these judgments are available online and in their official copy itself. So it is also, I mean, the purpose of the presentation could also be sort of to serve as reading recommendations in that regard, as to if you were to come across such a scenario while being involved in an arbitration, these might be the judgments to go to which might have an elaborate discussion on that principle. So MR Engineers versus Somdat Builders was a case where there were multiple agreements between the same party. So it was regarding a construction contract where, in short, there was sort of a mother agreement and there were multiple subsidiary agreements to that mother agreement. Now, I'm sure all of you have come across cases like that where between parties there will be one overall joint venture agreement of sorts, and under that there might be a design contract, there might be another contract for supply of certain limited materials, etc. So MR Engineers was was in the context of a case like that where the disputes arose under several of these contracts. So no one arbitration clause in one contract would cover the entirety of the dispute. So this posed a problem before the Supreme Court as to how would you deal with such a case where there is a large transaction which spills across the boundaries of more than just one contract. So to come up to deal with this scenario, the Supreme Court came up with two principles. The first was what was called as a composite reference, which is, or the group of contracts doctrine. There's a group of contracts doctrine and there's a group of companies doctrine. The composite reference is where there is one transaction which is spilt across multiple contracts, all of which, or if the mother agreement contains an arbitration agreement, then by invoking that arbitration agreement, the entirety of the transaction as a composite reference under all of those contracts is referred to arbitration. So typically we see cases where there is, the simple case would be one arbitration clause under one contract, the entirety of the dispute falls under that arbitration clause, a reference is made to an arbitrator. But suppose if there is a scenario where like this, where construction contracts, etc., where there are multiple clauses, it is made as a composite reference under all of those clauses. Now, even till date, we face more complicated scenarios where some of these arbitration clauses sometimes have different seats of arbitration. In those cases, it becomes very complicated because we've had cases where one arbitration clause provides for a seat in Singapore, whereas another arbitration clause provides for a seat in Chennai. So these might be contracts which have been entered into over a period of 10 years. So when the company was much smaller, they would have had arbitration seated in Chennai. As it grew, they've shifted to seated arbitrations in Singapore, etc. So then the question will be, where would the arbitration be seated? Where would the which procedural law would apply, etc. These, till date, they are complicated questions which will depend on the facts of the case. But typically, at least the composite reference principle means that you do not have to throw out these disputes right at the outset. That there is still a manner in which those references can be made. And incorporation by reference is a... Yes, sorry? Chennai and Singapore. So in that case, the question became as to determining which one is the mother agreement. So if I remember right, let me just... so there was a purchase contract. It was between a Japanese company and Indian manufacturing arm of this. So it was a separate Indian company which had been appointed as the distributor and manufacturer for their products. So when there were some sale agreements which had arbitration clauses seated in Chennai. There was also an agreement for the Japanese company to buy the shares of the Indian company. So that had a clause which had an arbitration agreement in Singapore. Then there was also another settlement agreement that had another arbitration clause in Chennai. So, and in fact, that was even more complicated because one provided for SIAC rules, one provided for Indian arbitration rules to apply, etc. What was ultimately done was, as on date, we have, it's still something which is ongoing, but as on date, the single judge's order was to say that the mother agreement is ultimately the shareholders agreement, because he identified it as being the final agreement which was more overarching than these individual purchase and supply orders, etc. And all those sale agreements, the consideration paid under that was also dealt with in the shareholders agreement. So he basically arrived at a view saying that this contract has been entered into with a view of the transaction as a whole. So this will be identified as the mother agreement, so to say. And therefore, under this arbitration clause, I will make the reference. So that will be the proper clause to cover the entirety of the dispute. So there are sort of cases like that for composite references which can be complicated. Incorporation by reference is a sort of allied principle where if you have, like I said earlier, where like Mr. Inbavijayan had said, there might be a case where there is a standard form contract, general conditions of contract which are applied by let's say BHEL or ONGC or a large PSU like that to all of their cases, and those are usually incorporated in their purchase orders. Now, those cases of incorporation can also be dangerous because the law in MR engineers, it also dealt with this issue of incorporation by reference. It's clear that where there is an incorporation by reference of an arbitration agreement, there should be a clear intent to incorporate the arbitration agreement itself. Because you may have heard this as a stray reference. The arbitration agreement, even if it is considered as a clause in a contract, it is an agreement which is an independent agreement on its own. So merely saying, let us say for example, if ONGC had a main supply contract with Reliance, for instance, that supply contract had an arbitration agreement. Subsequently, they enter into a purchase order for some other materials as well. In that purchase order, they merely say that all terms and conditions from the supply contract shall apply. That courts have interpreted to say is insufficient to incorporate the arbitration clause. You can't merely say all terms and conditions from another contract, supply contract will apply to incorporate the arbitration agreement. You have to make a specific reference to the arbitration agreement. So typically, to be on the side of abundant caution, what we do is all terms and conditions of the supply contract, including the arbitration agreement, shall stand incorporated into this purchase order. So yes, the reason why is because of this earlier principle that the arbitration clause is a separate and independent agreement. So even recently now, last year, the Supreme Court has decided this issue of stamping, for instance, where they said if a contract is insufficiently stamped, the arbitration agreement in that contract, whether it will be valid or not, was a question. The Supreme Court had taken very divergent views. Finally, now a 5-judge bench has decided that even if a contract is unstamped, the arbitration agreement will still be valid and binding on the basis that it's an independent and separate contract. So even though it's a part of it. So even though facially it is just a part, it's another clause in the contract which is just a part of the contract, for the way in which the law has developed, because the reason is this: if you were to go for an arbitration, if the arbitration agreement is not an independent contract, then if there is a termination of the contract as a whole, it would technically mean the arbitration agreement is also terminated. So jurists realized very early on that it would not be feasible to call the arbitration agreement as just another clause in the contract, in the main contract. So therefore, the jurisprudence evolved to say that an arbitration agreement is an agreement which is independent of the main contract, and it is a separate agreement. So therefore, even if the main contract is terminated, the arbitration agreement still survives. Even if the main contract is held to be void for reasons, maybe one party committed fraud, etc. If the arbitration agreement is held to be void, the main contract is held to be void, even in those cases, the arbitration agreement will still survive. So for that reason, it has been held to be an independent contract, and that is applied in cases like this as well. Yes, please.
Actually, arbitration agreement is linked to solve a dispute arising out of base contract.
Yes, sir.
The base contract is so wide.
Yes.
Then how we can cancel a dispute?
Yes, sir.
It's so wide.
Correct.
Then what was dispute referred? That is subdivision of main contract, right?
Correct, sir.
If main contract is viable,
Ah.
how we can say arbitration agreement will have its validity?
Yes, sir. So this view that you had taken was the initial view that jurists also tried to were initially taking, saying that the arbitration agreement is merely one clause in the main contract. So when the base contract itself goes, then how will the arbitration agreement continue to exist? So yes.
The arbitration agreement main focus to solve the dispute.
Yes.
Right?
Yes.
But the base contract is so wide. Then
Okay.
what about the dispute?
Oh. Got it, sir. No, typically I can see why you might consider it that way, to say that after that the dispute itself loses its importance. Why would we need to continue with the arbitration? What will happen is, even in those cases where the contract is held to be void, the party, so there'll be one party who, for example, has expended or invested a lot of money into that contract. he will say that this contract is held to be void due to, let us say, maybe, let us take an example, real life, sort of a real world example to illustrate it. If there is a case like a force majeure situation, if there is a flood which happens, and that the subject matter of the contract, let's say some cotton was to be supplied under the contract, due to the floods, the entirety of the cotton was destroyed. Now, in those cases, the seller, who has still supplied and procured that cotton from somewhere or imported it from somewhere, he has suffered some losses. He will say that while there is a force majeure event, while there is an external event which has destroyed the materials, now the contract is void because the underlying subject matter of the contract itself no longer exists. It stands frustrated in law basically, and as a consequence, it is void. Even in those cases, this party will want some compensation from the other party. He may try and argue saying that I have already, as per the terms of a contract, I have already title as transferred to you for this cotton. So I require the money that I have invested in this. Or he might at least try and say that return a portion of my investment to me. So to get that compensation, it is important for him to continue with the arbitration to get the compensation, which is why they treat the arbitration agreement as a separate agreement, so that for the purposes of arriving at what we call restitution, which is compensating the party for the losses which might have been suffered by them as a result of the contract becoming void or otherwise unenforceable. For that purpose, the arbitration agreement has to be kept alive, and that is why it is typically it is still. Yes. That's what you've. That's a very good question, because that's something which courts have grappled with for quite some time now. Because if there is a case of fraud, when fraud is arbitrable and when fraud is not arbitrable is a portion of jurisprudence that has been in the Supreme Court for I think at least about 20 years now. They've debated on it, starting from a 2006 judgment in Booz Allen, where what was initially the view was that all cases of fraud are not arbitrable. What happened as a consequence of that was defendants and dishonest defendant or a person who wants to avoid arbitration will just plead fraud. He will say, no, this person has acted in a fraudulent manner. And then he will tell the arbitrator, now that I have pleaded fraud and you have to determine whether fraud is there or not, it is not arbitrable. So you can no longer proceed with the arbitration. So to deal with such misuse of that fraud not being arbitrable principle, the Supreme Court has come up with a distinction between commercial fraud and actual criminal fraud. So what they've held in a recent judgment, which will be coming to in a bit, called Ayasami, is that established fraud cases where it is in the nature of a criminal fraud, that those types of cases are not arbitrable because they should be dealt with by the police in the state. But if it is a case where there is a commercial dishonesty, which typically can also be interpreted to be fraud, those will continue to be arbitrable. Just like a civil court can determine it, the arbitrator can determine it. So that's basically where it stands right now, sir. So coming to the second portion on two-tier arbitration clauses. Centrotrade, as I said, was that was an earlier example where there was actually two tiers of arbitration by judicial officers. But more typical two-tier arbitration clauses are when the first tier is by an independent engineer in a construction contract, like Chennai Metro follows that for a lot of their contracts. And then if the independent engineer's decision is found to be unacceptable by either party, they can then challenge it in an arbitration before a 3-member arbitration panel. So that is those clauses typically they're a little more complicated than this to formulate, because you then have to lay down what the grounds of appeal are, etc. But they also continue to exist. And the third, this is only by way of background as to the different types of arbitration agreements that can exist. The third is where there are multi-tier dispute resolution clauses, like in M.K. Shah Engineers and Contracts versus State of MP, where there was an agreement to first for the parties to try an amicable resolution by mediating upon the disputes by themselves. And if that amicable resolution fails, then to go for an arbitration, because ultimately arbitration involves a substantial investment of both time and money. So parties very often try to do this mechanism where at least for 30 days or 60 days, they'll keep a deadline because they wouldn't want the mediation to go on unendingly. You keep a deadline of about 30 days and 60 days and say that we will try and amicably resolve the disputes. If that fails, then we will go for an arbitration in accordance with the act. Oh, I think it's time for a tea break now. So in case, you have any other questions, etc., you can... Yeah. I hope it's okay to begin now. So having discussed the ingredients of the arbitration agreement itself, the next stage which we sort of come to is with regard to the reference stage, which is when you are going for an appointment, whether it is before a arbitral forum, whether that is an institutional forum, or whether it is before the High Court or the Supreme Court. What generally the law in India is now very well developed, that it's what's called as the deadwood principle, which is unless deadwood the wood which is not suitable for any use whatsoever, which is floating in this thing, except those claims which are from a prima facie view, from a preliminary view itself, if the claim is dead, then those may not be referred to arbitration. For instance, if it's a 100-year-old claim which is clearly barred by limitation, then those will not be referred to arbitration, except those cases. In all other cases, the pro-arbitration approach is adopted to refer these claims to arbitration. So, the second principle to be followed is the pro-arbitration approach by the appointing authorities. Composite reference we had already discussed. Coming to another very important judicial precedent which is recently developed is the judgment of Cox and Kings versus SAP India, which was the citation is the reference is also given there, 2023 INSE 1051, which has developed this concept called the group of companies doctrine. Now, as chartered accountants, you're very familiar with the corporate wheel theory as to how each company has its own separate legal personality. This carries a lot of importance when it comes to an arbitration context as well, because when quite often what happens is that there may be group arbitration agreements and contracts between multiple group companies, group entities. So they may not be the same entities who entered into different contracts, especially today with multinational corporations, etc. The same corporation will have a Japanese head office, they'll have a Thai subordinate office, and they'll have one other subsidiary in India. Each of these contractors might have separately entered into contracts with an Indian entity. So in those cases, the question that then arises is whether all these parties can be bound by one arbitration rather than have multiple arbitration and multiple claims between the same parties, because they're essentially between the same corporate groups. So in that scenario, what the Supreme Court has evolved is this group of companies doctrine, which is to say that if a group of companies has functioned as a single economic entity, where in the discharge of the transaction or in the discharge of their work under that contract, if they have functioned as a single economic entity, then it can be referred to a single arbitration rather than have multiple arbitrations for each separate dispute. Now, while discussing in what cases, because typically arbitration, like we said in the beginning, party autonomy is the fundamental principle. So if a party consents to arbitration, he can be referred to arbitration. Otherwise, a party who has not consented or who has not signed an arbitration agreement cannot be relegated to arbitration. Now, there are certain exceptions to this principle of saying that a non-signatory party or a party who is not a party to the contract cannot be referred to arbitration. That the Supreme Court has they've classified it as consent-based theory and non-consent-based theory. So this is for you to sort of keep in mind when you are advising clients as to whether or not they'll be bound by an arbitration clause. It's important, the first stage of review is to see, have they signed any contract which has an arbitration clause? Okay, they've not signed any contract which has an arbitration clause. Does that necessarily mean that they will never be subject to an arbitration with the other party? They can still be subject to an arbitration with the other party if they satisfy any of these consent or non-consent based theories. Now, what are the consent based theories? One, novation, where, for example, a party who has not both novation, assignment and third party beneficiaries, these three are very close to each other because they are all cases where a party may not be a party to the main contract, but subsequently they signed an agreement with the same parties novating that previous agreement, or they obtained an assignment of the contract from the earlier contracting parties. In all those cases where they are either an assignee or a party who has entered by way of a novation contract, in those cases they can still be bound by the original arbitration agreement contained in the main contract between the parties. Interesting question, sir, because typically when there are two types of cases. One is where the subcontractor is making a claim. Second is when there is a claim being made against the subcontractor. In a case where a subcontractor is making the claim, they can say to the employer, let us say ONGC has a contract, they've given it to somebody like Reliance, Reliance has subcontracted it to somebody else. That subcontractor, they can say that they are an agent or a party who is claiming through the main contractor and can seek to directly make a claim against the ONGC. But in several cases, what will happen is if the contract has a clause which says that they are contracting on a principal to principal basis, that neither party will be considered to be the agent of the other, that will then disqualify him by removing him from that main contract's ambit. Because once it becomes principal to principal, then he cannot make a claim through the main contractor. But if it is understood that the subcontractor is an agent of the main contractor, then he can make a claim saying that I am claiming through the... In that case, the arbitration agreement will apply to the subcontractor's claim as well. But that will depend on the very particular wording of the contract where he should be seen to be an agent. Yes. Sorry, sir? Yes, yes.
Say, for example, HO is giving guarantee to Indian subsidiary.
Yeah.
Guarantor.
Yeah.
HO is a guarantor. Foreign.
Yes, yes.
In that case, subsidy is not some kind of, okay, they borrowed some money from bank, right?
Okay.
So in that case, in between bank and the Indian subsidiary, there will be some arbitration.
Yeah,
Right?
yeah.
Since
Let's say.
money is acting as the guarantor.
Hmm.
In that case, guarantor also to be bind by this internal arbitration.
So typically no, because a contract of guarantee again is a separate contract. So the main loan agreement, unless the guarantor has also agreed somewhere to be, especially because in the example which you've given, HUL is the parent company. They are not, suppose if it had been the other way around, if it had been 100% subsidiary of the main company which was giving a guarantee to the parent company and the parent company had taken a loan, in those cases the bank can still try to include the subsidiary also as a party to the arbitration by saying that you are ultimately you are 100% subsidiary, you are wholly owned and controlled by the parent company. It is different, that's what. In yes.
Giving guarantee to the bank, Indian banker, based on the guarantee, the Indian subsidiary awaits some loan, borrowed the loan. Now arbitration agreement actually in between Indian subsidiary and
The bank, yeah.
now they acted as a guarantor, right?
Correct.
They fall under the economic entity. Based on that,
Okay. Whether you can invoke single economic entity principle in those cases, it will depend on the extent of control and ownership which the holding company has over the subsidiary company. If they are, for example, if they have 100% shareholding control and if they have full board control of the subsidiary company as well, and if in this transaction for which the loan was used or whatever the purpose was, if the holding company has also benefited from that transaction, if either they've gotten revenue from the transaction or they have somehow indirectly benefited by a rise in the value of the shares, in all those factors can be used as facts to say that there is a single economic entity functioning there, and therefore it should be treated as a group of companies doctrine should be invoked to, not group of companies doctrine, you should pierce the corporate veil and you should refer all parties to arbitration. That argument can be made, yeah. Citation for this, I'll actually have to check for this thing because MR engineers had the same entities which were functioning under different contracts. Where there is a parent and subsidiary company, chloro controls will apply, sir. Chloro controls, there is a judgment of the Supreme Court, which it's in fact, if you were to read Cox and Kings itself, Cox and Kings it's a large judgment, but it discusses each of these situations. In fact, it's very interesting if you go into it because as chartered accountants, you no doubt, I mean, you're familiar with the corporate veil theory. They say that the group of companies doctrine is different from the corporate veil theory because corporate veil theory is non-consent based. So parties are not consenting there. The third party, that is the judge or the arbitrator, is saying that here I feel that there are reasons, the facts justify the piercing of the corporate veil. Group of companies doctrine is saying that two or more companies, which may be part of the same group of companies, they are all functioning as, they've agreed and they're voluntarily they are functioning as a single entity, and therefore they've agreed to be bound by the arbitration. So it's a technical nuance, but basically in both cases you can hold group companies as party to the same arbitration agreement. Cox and Kings discusses each of these cases in fair detail, so to look at the citation. And so I was in, subsequently other consent-based theories are either merger or succession, where by virtue of a merger, let's say another group company gets merged into the company which had signed the arbitration agreement, then that merged entity will still be bound by the arbitration agreement because it will be succeeding to the rights and liabilities of the earlier entity. Similarly with succession as well, that if succession typically in a shareholder agreement context perhaps, where if the shareholder agreement is clear that all successors and assigns are bound, then even if one shareholder passes away, his legal heirs can still be bound by that arbitration agreement, because the original shareholder, let us say the father or mother in the scenario, they have agreed to be bound by an arbitration agreement with regard to their shareholding in that company. So in typical promoter disputes, this comes up sometimes. Now, coming to the next portion on fees. Yeah, this is interesting. If where there comes a situation where, let's say, where you're functioning as an arbitrator, an important this thing is, of course, the fees as to what an arbitrator can charge and how it is usually determined in law. The first principle still remains that party autonomy is paramount even in the context of fees, in the sense that if parties can agree, if parties agree saying that the Indian Arbitration Act will apply, then the rules which are framed under the Act, as Mr. Inbavijayan said, there's only a model schedule. It is not a binding schedule, which is Schedule 4 to the Arbitration Act, prescribes the slabs of fees which can be charged by an arbitrator depending upon the quantum of the claim and counterclaim involved. That again is only a model schedule which is not binding upon the parties. But what the parties decide will be binding upon the arbitrator. So if the parties say that, let us say, this is an extreme case, it's typically not done, but the parties say that we will go for an arbitration, any arbitrator we appoint will be bound by this schedule of fees, then that is binding upon the arbitrator who they appoint. Let us say, even if it is a high court judge, if that arbitration agreement is being enforced, they will be bound to charge as per the schedule provided in the agreement between the parties. The exception, because quite often practically, when we've advised parties, we've seen that parties feel that the arbitrator has the authority to decide what the fees will be. It is actually the reverse in law. The parties can decide what the arbitrator's fees will be, either in the contract itself or at the time of the arbitration. In the contract itself, let us say, now recently last year, the Madras High Court has come out with arbitration rules which also provide for the arbitrator's fees. They are more or less in line with what is provided in Schedule 4 of the Arbitration Act. There are the Madras High Court Administrative Costs and Arbitration Rules of 2014, which were recently also amended. Those, for example, if they are incorporated into the contract, then the arbitrator will be bound to charge only as per that slab. Or the parties can agree on another fee as well. Now, in practical this thing though, the Supreme Court, while considering this, in ONGC versus AFCONS, they have held that an arbitrator cannot unilaterally determine what his fees could be, and that the fees, it will either be what the parties have decided or the parties have chosen an institution, what the institution decides will be the fees for the arbitrator. So this, going back to what Sriram had said, it will fall within the ambit of the rules governing the arbitration proceedings. It will also include if that LCIA or if SIAC, they also have slabs of fees which are provided for their panel arbitrators. So that will then be binding on the arbitrator if you opt for an institutional mechanism. If you opt for an ad hoc mechanism, then if you say that you can still opt saying that the Madras High Court rules or some other rules will apply in the fees, on the fees aspect alone. Now, coming to the arbitration stage itself, that once an arbitrator starts functioning, then there are typically the first challenge for an arbitrator will be that there might be some jurisdictional challenges which are raised. There it is, there's something called the competence principle, which is, I mean, it was evolved from German law. The federal court in Germany that first came up with it, which is why it's spelled so strangely. This competence principle basically envisages that the arbitrator has the competence to determine his own jurisdiction. That is just like another court, because typically otherwise, because he is appointed under a contract between the parties, earlier parties would argue saying that no, how can he determine his jurisdiction? It has to be the court under which he comes that should determine whether or not he can decide this dispute. That would mean that there are too many references to courts and arbitrations become more prolonged. So courts evolve this jurisdictional principle that arbitrators can decide their own jurisdiction, which will then, of course, at the time of the final award, etc., it could be subject to the supervision of the court. So, based on the competence principle, this is the only extract which I distinct on. Ayasami versus Paramasivam, which is again the case which deals with that fraud and established fraud doubt that you had raised, sir. It says that again, ma'am, this also deals with that independent arbitration agreement principle, which is the severability of the arbitration agreement is a doctrinal development of crucial significance, for it leaves the adjudicatory power of the arbitral tribunal unaffected over any objection that the main contract between the parties is affected by fraud or undue influence, or any other factor which makes it void as well. So this is why they've sort of evolved this principle of the severability and the independence of the arbitration agreement. Now, coming to jurisdictional challenges, typically this is only to give a sort of practical insight into what sort of challenges are usually raised by lawyers who want to avoid the arbitration. One will be regarding the existence or validity of the arbitration agreement. To say that either the party did not consent or did not sign to this arbitration agreement, or to say that even if this arbitration agreement is there, it is vague. For instance, if an arbitration agreement says both that it will be subject to the jurisdiction of courts in Chennai, but also says that the seat of arbitration shall be Singapore. If there are conflicting stipulations like that in an agreement, then they will try and argue that it is a vague agreement and therefore it cannot be enforced by the parties. The third sort of situation is saying that the dispute which has been raised falls outside the scope of reference, which is to say that, like we said earlier, if there is a main contract for a supply of certain materials, and it says that only disputes under this contract shall be referred to arbitration, and if parties subsequently also issue a purchase order for supply of certain other materials not covered under the main contract, same parties, but they will argue saying that no, this is not under this contract, so it falls outside the scope of the arbitration agreement. So that will be another jurisdictional challenge which is typically raised before arbitrators. The last two will be limitation and arbitrability. Limitation is to say that for any sort of civil claim in India, there is a limitation period which is prescribed as to within what time such a claim can be brought for adjudication. Typically for money claims, it is 3 years from the time when the cause of action arose, which is from the time when the dispute arose. Now, within this period of 3 years, if let us say a claim is brought 6 years or 7 years later, typically the defending party will take a stand saying that no, this claim is barred by the limitation law and therefore it cannot be referred, this arbitration cannot continue. In most cases, arbitrators take a view that this is a mixed question of fact and law, because it will not, because one thing which I missed out saying is all these jurisdictional challenges, if they involve questions of fact to be determined, then as arbitrators you are entitled to leave that till the final hearing stage, because if it is a question of fact which has to be determined, then evidence has to be taken as well. And if evidence has to be taken, then you need a full-fledged trial. So it cannot be determined at the initial stage of a section 16 application or without a full-fledged hearing of the parties. So in most cases, if there is a mixed question of fact and law like limitation, because in limitation one question will be as to when the cause of action arose between the parties, when the dispute arose. One party might say that there were some settlement talks etc. between us, so actually he didn't refuse to pay me until about 2 years after the original default date. In all those cases, there will be a question of whether limitation bar applies or not, which will be a mixed question of fact and law. And therefore, it will go into final hearing rather than be determined at an initial stage itself. Now, two aspects. Arbitrability I'll be coming to on the next slide. That is, according to me, the most, let's say the most interesting subtopic with regard to maintainability of claims. One small aspect that should be dealt with is there is always this question in when you're functioning as an arbitrator, if a section 16 application is filed saying that this tribunal does not have jurisdiction, one of these jurisdictional challenges is raised, either limitation or saying that it is beyond the scope of the reference. Does that have to be determined immediately or can that be kept for a subsequent stage in the arbitration? For that question was answered by the Supreme Court in Maharshi Dayanand University versus Anand Cooperative Society in 2007, where the Supreme Court discussed this at great length and held that this can also be framed as a preliminary issue for the final hearing. It need not always be determined right at the outset. It is left for the arbitrator's discretion whether he or she wants to determine it right in the beginning, or if they feel that some trial is required, so we will determine it at the final hearing stage. But before going into any of the other issues, they have to determine this issue of jurisdiction. So as long as the award deals with the issue as a preliminary issue, it is acceptable even if it is not dealt with right at the outset. Now coming to the issue of arbitrability, which is one of the main, let's say, which is jurisprudentially one of the more interesting aspects when it comes to these challenges, is I think Inbavijayan sir had briefly touched upon this aspect of rights in rem and rights in personam. This pertains to our understanding of arbitrations as a whole, because typically in arbitrations, what is happening is two parties are having a contract agreeing to refer their disputes to a private dispute resolution mechanism. So several disputes by their very nature cannot be referred to this sort of private dispute resolution mechanism. To sort of identify what these disputes are, one broad overarching category is these actions in rem and actions in personam. He had said he'd refer to rights in rem and rights in personam. I'll just briefly rephrase that to be actions in rem and actions in personam. Actions in rem are basically disputes where the adjudication cannot be conducted behind closed doors by just two parties. So typically, if there is a dispute which determines your title to, let us say, a land or an intellectual property or a patent or a copyright of some sort, if it is once your title is determined, that is ultimately a declaration to the world saying that so and so person has title to that property. It is not just against the counterparty in that matter. Though, I mean, legally there is a small this thing in section 34 of the specifically fact, but without going into that, when there are cases like that, when your right is being determined against the world at large, those become actions in rem, where it is not just the counterparty. Because, for example, a person and their wife should not be allowed to just raise a fake dispute over who has title over a copyright and get an arbitral award saying that the husband has the right, and that is basically to enter into a collusive arbitration and to decide on a title dispute over a property, for example. If there is a property in Velachery, two people cannot collusively decide that A has property to that, A has title to that property. So in those cases where there are title disputes, etc., which are involved, those are actions in rem and they should go before civil courts. But if it's an action in personam, where it is a contractual dispute, or if it is a dispute which only concerns two parties, those disputes can go before an arbitration tribunal. Now, even with intellectual property disputes, for instance, while the title or the right to claim a copyright or a patent cannot go before an arbitral forum, if there is an issue of only copyright infringement, let us say if somebody alleges that A alleges that B has stolen his film script or something, that can technically go for an arbitration because it still remains an action in personam. Because as long as B does not challenge the title of A, as long as the validity of the copyright or the title is not in challenge, it can go for an arbitration as well. Now, coming to the other exceptions, the Supreme Court in Vidyadrolya versus Durga Trading, it has laid down broadly, this is sort of taking from that decision, broadly the types of disputes which cannot go for arbitration. The first are disputes which have an erga omne effect. Erga omne effect being, again, it is against the world. Erga as in against and omne against everyone. So where there is an erga omnes effect in terms of title is the best example, where there is title to any sort of property that is in question. Those are considered to have erga omnes effect and therefore they are not suitable for arbitration. The second are cases which involve sovereign functions of the state, like taxation, police powers. Those are the two most popular eminent domain, land acquisition. All of those are cases where the state is exercising its sovereign power. So a challenge to that exercise of sovereign power by the state can never go for arbitration, because that they hold will have impact on other citizens as well. So therefore, and there is a public interest in not referring it to arbitration. The third are cases where public policy requires a state monopoly. Now that sort of matrimonial causes are sort of an instance for that, because from a moral standpoint there is a policy decision that matrimonial causes with regard to divorce, etc., with regard to pronouncing a couple to be divorced, that is something which only the state should be allowed to determine and not a private contractual forum. So for those reasons, certain cases like matrimonial causes, public policy itself excludes and says that a state forum alone should determine it. And the fourth and final this thing is where there are special fora and implicit non-arbitrability, which are cases like what Mr. Inbavijayan had said in the context of rent control tribunals are one instance, where there is a special forum which is provided. Another instance is with regard to competition law tribunals. Now, in the US, for instance, even competition law disputes are arbitrable between companies. But in India, if it is a dispute pertaining to a violation of the Competition Act, then it is not arbitrable even if the parties involved agree to an arbitration, because there is a special forum which is provided in the form of the Competition Commission and the Appellate Tribunal, and only that forum is vested with exclusive jurisdiction under the Act. So, if there is a tribunal which is vested with exclusive jurisdiction typically under any statute, then in all those cases arbitration is ousted. So, these are broadly the categories in which arbitrability, where a dispute can be held to be non-arbitrable. Now, coming to the next portion, which is once we are past the stage of once you pass the stage of a jurisdictional challenge, the next stage comes to the merits of the dispute. As an arbitrator, breach typically is a factual issue. Like Mr. Inbavijayan has said, it is a question which will turn on the facts of each individual case and on the law applicable to each individual case. So, as a general principle, laying down any rule for how to determine breach, etc., may not be possible. But some factors to remember when when a person is adjudicating as an arbitrator is first that the arbitrator is ultimately a creature of the contract. He or she is not somebody who is vested with any statutory or constitutional authority. Two parties are agreeing to refer a dispute to him by virtue of a contract, and that agreement is getting sanctity by virtue of a statute in our country, which is the Arbitration Act. So once they are a creature of the contract, the Supreme Court in SCI Chandu construction and in other cases as well has time and again held that they cannot go beyond the four corners of the contract. For instance, it is the traditional view, and this is largely followed even now, is that an arbitrator cannot strike down a provision in the contract. If there is, for example, if there is a provision in the contract which says that any party, even if there is a breach, they will only be entitled to whatever actual costs or actual losses they have suffered. They will not be entitled to claim any loss of profit. The arbitrator cannot say, no, I feel that this clause is very unfair in this case. I will strike down the clause, I will not go by the clause, and I will award loss of profit to the party. That would be him exceeding the four corners of the contract, and something which the arbitrator does not have the power to do. So, unlike, whereas a civil court has the power in an exceptional situation, because for instance, if we take our original side High Court itself. Yes, sir. Sorry, I think it's coming too close. Is it because it's coming close to this and then? Yes, sir.
You already said one thing. Arbitrary agreement is independent one, right?
Yes.
So,
Yes.
the arbitrator has right to go beyond what was stated in arbitrary agreement, right?
No,
in
sir.
terms of compensation.
Yes, sir. So it is an independent agreement, but it remains an agreement between the parties. It is still only a contract. So the arbitrator, their power to adjudicate is only coming from that contract. Whereas, let us say, if you take the civil court, for example, High Court, for example, it has its power to adjudicate is not coming because both of us agreed to give that High Court the power. The power is coming from the Code of Civil Procedure and the other laws. Yeah, yeah.
Arbitration agreement one, right? First, okay, there is contract agreement in between parties, right? The business contract agreement itself, suppose both parties agree for compensation in case of breach of contract.
Yeah.
Then, in that case, arbitrator has any right to go beyond what was stated in the base agreement?
They cannot. So he can only decide within that whatever is agreed by the parties. In the basic contract, yes. Oh, though it's an independent. Oh, that's okay. Now only I understood your question. Though, yes. Though it is an.
He can't override that what was stated in compensation stated in
That's a good question. In fact, I don't think even a court has dealt with this question exactly like this till now, to my knowledge at least. The issue is that although it is a independent contract, although it is a contract which is independent and separate from the main contract, the arbitrator is only empowered to decide within that contract's this thing. It is, let's say for example, in fact, some light may be shed if I come to the second portion of that as well, is this principle called equity which is there, yeah? Which says that in the Arbitration Act, it is referred to as ex acquio e bono. It's a Latin phrase to mean that in good faith and this thing, equity. So that parties have to specifically agree and confer that power on the arbitrator. Let us say in the arbitration clause which we had discussed earlier, parties can also add a line saying that the arbitrator appointed shall have the powers to decide the dispute ex acquio e bono. That means that beyond the arbitrator will have the power to travel beyond the contract and to look at equity while deciding the dispute. But if that language is not used in the arbitration agreement, it means that the parties intend that the arbitrator has to be bound by the four corners of the main contract. If they want the arbitrator to have the power to decide on fairness and equity, equity typically in law is the principle of fairness which goes beyond any defined contractual relationship or defined statutory relationship. So if you want or if you trust the arbitrator to have such powers also, then you add this wording in the arbitration agreement to say that they can also decide ex acquio e bono. He can go, that will give him the liberty to go beyond that to some extent at least, yes. He may not be able to strike it down, but he can say that this clause is there, but I feel that fairness mandates that I also give them some compensation in exercise of my equitable jurisdiction, and that I can do. So he cannot strike down the clause still, but he can invoke this to then grant compensation. So that's the sort of the delineation between an arbitrator deciding purely in terms of the contract and by exercising principles of equity. The next judgment which I'm coming to is McDermott International versus Bern Standard. This is more of a reading recommendation if you find yourselves in the position of an arbitrator and wanting to quantify damages. This judgment has one of the best discussions by the Supreme Court as to how you should compute damages. So in India, typically we are a jurisdiction which is very conservative when it comes to awarding damages. Judges are usually very particular as to saying that you have to identify the actual amount of loss which you have suffered. Whatever that quantifiable amount is, I will give you that amount, and maybe some small additional cost. But apart from that, unlike let us say the US or certain other jurisdictions, we are not very liberal when it comes to awarding special damages of any sort. This especially in the pre-liberalization context. Post-liberalization, once larger companies came in and there was a more capitalist outlook to how contractual relations should be governed, the Supreme Court also took a more liberal view in McDermott International to say that you can apply internationally applied formulas. There are basically, you probably know that better, there are 3 or 4 formulas which are used mainly in the construction contract context to decide on damages. When there is the Hudson formula, the Aiklin formula, and there's one more that name slips me, but all 3 are discussed in McDermott, which are exact formulas to determine how overheads and loss of profits should be awarded by an arbitrator when it comes to computation of damages. So there are also judgments which of recent times we say that if you cannot exactly compute the damages, you can even go on a sort of scientific guesswork principle. But while the guesswork principle is sort of still in its nascent stages in terms of discussion in judicial precedents, a more established judicial precedents is McDermott, where they've discussed these 3 formulas and they say you can award overheads and which will roughly come to about 15% of the contract value, and loss of profits based on these formulae which are dealt with in the judgment itself. Now, again, there are one sort of sidebar in that regard is the evolving principles with regard to reliance-based interest and expectation-based interest. Because I have some time, I'll deal with this very briefly. Typically, if you're functioning as an arbitrator and if there is a scenario where you're computing damages, broadly there are 2 ways in which damages can be awarded. Typically, it's in a case where there is a breach of contract. One party has suffered a loss due to the conduct of another party. Either the first party, let us say, has terminated the contract, or for some other reason they have refused to perform the contract, the other party has lost whatever it has invested in that contract. In all these cases, there are two ways in which damages can be given. One is reliance based damages, and the second is expectation based damages. Reliance based damages are damages which are backward looking. Basically, reliance based damages see what is the expenditure which the party has put into the performance of a contract, and give them back all that expenditure, what we call wasted expenditure, that they incur during the performance of the contract, which has now become nullified. So reliance based damages will be backward looking, where you give them all the wasted expenditure that a party has incurred. Expectation based damages is looking forward to see what is the revenue that the party would have generated from the contract, and giving them that revenue, which would include the loss, the profits as well. So it is left to the court or for the arbitrator to determine as to what is more suitable in any case. In some cases where let us say if it's like a force majeure event, like a flood destroying the cotton, etc., where it is not the fault of either party, typically courts give reliance based damages where they say we'll give you back your expenditure but we can't give you profits, because it is not his fault that the contract was broken. But if it is a case where a party by fraud or misrepresentation has broken a contract, or has resulted in the non-performance or termination of a contract, in those cases they can give, courts are more inclined to give expectation based damages, which will involve giving a share of profits as well, the reasonable profits that they would have made from the contract as well. This principles, the Supreme Court is only now touching upon it. There is a judgment called Kanchan Udyog, where the Supreme Court has discussed this principle of reliance based and expectation based damages. I'm forgetting the other counterparty's name because it's a little out of the arbitration context, it's not directly this thing. So Kanchan Udyog, the Supreme Court has discussed these two principles in brief, but it is evolving much more. In the UK, etc., it has evolved much further, and there is still place for it to evolve. So while granting damages, this is another aspect which arbitrators should typically look into. Now, the final portion is with regard to the writing of the award itself, or what are the things to avoid while deciding as an arbitrator. Because while we are a pro-arbitration jurisdiction, typically courts will be very hands-off when it comes to interfering with an arbitral award. It is not like a case where if you have a typical civil dispute, you file it before the lower court, you come on an appeal, all the questions you argued before the lower court, again you can argue before the appellate court as well. But in an arbitration, the law wants to achieve a quicker dispute resolution mechanism. So to keep the time frame quicker, they made it clear that if there is a challenge to an arbitral award, it should be done on very narrow grounds. It is not that you can raise all questions, all factual issues, all evidentiary issues again before the court where you are challenging the arbitral award. There are very limited or narrow scope of challenge which is available. There are innumerable number of judgments. So while discussing key legal precedents, this is one difficulty, because there are thousands of judgments in arbitration law where there are at least hundreds which are relevant, which are helpful in terms of helping our understanding of the law. But these are some of the judgments which we've identified, which will give an overview or an overall outlook regarding the principle. So Sangyong versus National Highways Authority of India is one such judgment which has now discussed the principles with regard to a challenge to an arbitral award under section 34. It talks about both. Basically section 34 lays down what are the grounds on which you can challenge an arbitral award. Now there are certain grounds which are very clear, which are things like where one of the parties was not given adequate notice regarding the arbitration, or where one of the parties did not have the capacity to, let us say if somebody else came as the authorized representative for a company and participated in the arbitration, the company can then challenge saying that he was not even my authorized representative, he was set up, so therefore they can challenge the arbitral award and get it set aside. So those are more clear-cut cases which are in black and white. But there might also be cases where an arbitral award which is passed, while the parties had full capacity and had fully participated in the arbitration process, the arbitrator might have made certain errors in the award. Now, typical errors would either in the interpretation of the contract, there might be an error, or in appreciating some evidence. He might have missed out some letter or some oral evidence which was given by one witness while writing the award. That sort of error might be there. Or there may be more serious errors. What the law in India basically holds is, unless the error is more than just an error in the interpretation or an error in the appreciation of evidence, the courts should not interfere with it. So it sounds a little counterintuitive, because admittedly there is a mistake in the award, but the court will not interfere unless that mistake is of a standard whereby it either is opposed to the public policy of India, or it is what is called as if it is patently illegal. So patent illegality, again, this is a small distinction. It's only available as a ground for challenge in domestic arbitrations, not for international. But basically, public policy and patent illegality as two grounds for challenge. Public policy has been interpreted again to mean two things. One is the fundamental policy of Indian law, and second is the basic notions of morality and justice. So the arbitration award should be seen to be opposed to either of these principles for it to be struck down on the grounds of public policy. There again, for deciding what constitutes fundamental policy of Indian law, because the court is very clear that every statute or every law in India is not part of the fundamental policy of Indian law. So then to identify what is the fundamental policy of Indian law in Sangyong, I think Justice Nariman, who had given the judgment, he relied on an earlier judgment of his own in Associate Builders versus DDA to say that it would involve more than just a mere statutory violation, but if it is a statute which is important to the public interest of India, for example, FEMA violation was taken to be there is an award which resulted in a violation of the FEMA laws, was taken to be opposed to the violation opposed to the fundamental policy of Indian law. But if it is a similar arbitral award which is only, let us say, violative of some more minor law in India, for example, if there is some labor legislation which it has ignored or which it has overlooked, or it has enabled a violation of some labor legislation, that will still be condoned by the court. But so, or it should be a case where it has disregarded the judgment of some superior court. So where there was a binding precedent and that was disregarded by the arbitrator despite it being placed before the arbitrator, that could be seen as something which is against the fundamental policy of Indian law. Then morality, it's defined in section 23 of the Contract Act. For example, if there are arbitral awards which enforce contracts which are considered to be immoral, like there are certain contracts which section 23 of the Contract Act recognizes as being immoral. For example, a contract to one of the prominent examples that is used as an illustration in section 23 itself is a contract for concubinage, where if there is some sort of a contract which is entered into for performing an illegal activity, adultery for example, that contract being enforced by an arbitral award, that award will be considered to be opposed to the fundamental notions of morality. And similarly, the fundamental notions of justice is more ephemeral, it's more hard to define. It is basically defined to mean anything that will shock the conscience of the court. That will of course depend on the individual judge who is involved. So that gives the courts a certain amount of leeway, but the understanding there is that the court should interfere only in very narrow circumstances. And that's about the end of the presentation itself. If there are any other questions, I'd be happy to take it. Yeah. Yes. Sorry. Yeah. Okay.
Are they accepting it, and how many of them go land up in
Okay. So, So, ma'am's question was regarding to what extent are arbitral awards considered as to what extent are arbitral awards considered as final, and to what extent are parties challenging these awards in court. Ma'am, in most cases which we see, where the parties have some capacity, and typically most parties who are going for an arbitration have some economic capacity because they're able to pay the arbitrator and go for that process. So in most of those cases, the parties don't usually, if it goes against them, they don't accept finality. Even if it is a bad case, they will take it up to the High Court to take a chance. So practically what happens is there is still a prolonged litigation which is involved, but because of that narrow scope of appeal, it gets resolved quicker. So if a typical appeal takes about 3-4 years for a High Court to determine, a typical section 34 will get determined about 1.5 years to 2 years. So that little time saving is there, but most cases parties don't accept finality. The few cases in which parties accept finality are the small finance company arbitrations, where there will be a borrower and a finance company, where they have an arbitration typically the borrower does not have the wherewithal to come and participate in the because he's somebody who probably has already defaulted on a loan. So already he has no money to come and participate. So he will let the finance company conduct that arbitration, let the award be passed, and they will usually not have the ability to challenge it also. Except those few cases where due to economic inability they don't come. It is usually not treated as final, but the scope of challenge is narrower. That's the only little time saving that sort of comes in. But that seems to be enough of a benefit, because from what we see in practice, at least almost all large corporations include arbitration agreements in their contracts. Because of late, of whoever we've dealt with in my limited experience, I've not seen any case where a party opts out of having an arbitration agreement and leaves the dispute only to resolution by court. Because if nothing else, within a year, year and a half, they can get a first round of dispute resolution done. That's the. Any other questions? Sir?
But one contract has one arbitration class.
Yes.
Okay, not exactly separated arbitration agreement.
Yeah.
Based on that, conduct one class about arbitration.
Yes.
Okay. But whether the party, with notwithstanding that class, whether the party approaches civil court to resolve the dispute.
Sorry, I should keep my phone. So, sir, typically whether party can approach a civil court even if a contract contains an arbitration clause which does not constitute an arbitration agreement of its own. That's your question, yes, sir. For that, so it's sort of black and white, sir. If the clause which is contained in the contract can be read to be a valid, so those ingredients which we had discussed, section 7 and what was discussed in KK Modi, KN Modi, etc. In those cases, if those ingredients are found to be there in the clause, what we had sort of outlined in our initial portion, if that is there, then it becomes a valid arbitration agreement. Once it becomes a valid arbitration agreement, party cannot go to court. If one party goes to court, the other party has the option of filing something called an application under section 8 of the Arbitration Act, where in any civil court, even in NCLT, etc., they can file a section 8 application saying that no, this dispute is actually subject of an arbitration agreement, so refer it to arbitration. And that court will be bound to make that reference. It may not be empowered to appoint the arbitrator, but if nothing else, it will say we cannot continue with the dispute because it's covered by an arbitration agreement. Even if it is only a clause. For instance, let's look at it as the reverse. The simplest form of an arbitration clause. If parties just state in their contract that any dispute arising out of or any dispute arising in connection with this agreement shall be referred to arbitration under the Indian Arbitration and Conciliation Act 1996. I would argue that even if they don't say it is binding, even if they say that it is not final and binding, they don't say what the seat is, etc., it will still be a valid arbitration agreement, because the Indian Arbitration Act contains the provisions to say what will be the applicable law when the agreement is silent. Like for instance, the speakers who came before me explained that if the arbitration agreement is silent, then the presumption it is one arbitrator. Similarly, if the arbitration agreement is silent on the procedural law, then the Indian Arbitration Act's procedure will apply to the arbitration. So one arbitrator being governed, and if it is silent on what the appointing court is, they will look at the closest nexus. The nexus test will be applied to see which court has the closest connection, and they will apply, use that jurisdiction. So even that single line clause can be considered to be a valid arbitration agreement. Typically, you wouldn't want to risk it with just a single line. Typically, if you're going for an arbitration agreement, you'd want to make it clear and categorical with a paragraph at least. But even that single line clause can be considered as a valid arbitration agreement. Yes.
Generally, the single line only when we are finding.
Yeah.
Go for that, and they add the court.
Yeah. Which court will? Yes.
The other,
Yeah.
what happens then for the whole arbitrator to be appointed? Because as you mentioned, the peacetime
Yeah.
all be fine.
Yes.
Later on, when it is
Wartime, then it becomes.
they not be agreeing on anything, then how to go about with appointing the sole arbitrator?
Yes, ma'am. So, interesting this thing, because in practically what happens is, sometimes with larger commercial parties, the default position is that if it is like that, if it is a single line clause where there is no there is no mechanism, detailed mechanism provided, parties have to try and agree on an arbitrator. If they fail to agree, they have to go to the jurisdiction, the court which is specified. They'll have to go to the jurisdictional high court or Supreme Court if it is an international commercial arbitration, and ask for an appointment by the court. Most cases, like you say, parties don't agree. But for instance, we ourselves had a recent case where there was a dispute between an Indian promoter and a Spanish investor, where parties are at loggerheads. For months they've been fighting and they've not been able to agree on anything else. But when we sent the arbitration, we were initiating the arbitration, we sent the arbitration notice proposing 3 names. So in that, one name was acceptable to the other party, surprisingly, because if it is somebody of such an eminent standing, like for example, let us take a financial arbitration, if it is a chartered accountant who is so senior that nobody doubts his or her integrity and honesty, then in those situations both parties might be agreeable to go for an arbitration, only because it will save them time. Because in this case, the Spanish investors' logic, I'm presuming, because I'm only advising the Indian promoter, but the Spanish investors' logic would have been, if not for this, we have to go for arbitration appointment through the Mumbai, in that case, it is the Mumbai International Arbitration Center. You have to go through the MCIA, and that will take time, that will take expense, etc. Why go through all that? This person we can trust, so we will go with this person. So that can happen with commercial parties sometimes, but we've seen family disputes, for instance, where typically when brothers start fighting, that becomes very acrimonious. So in those sorts of cases, they will not agree on anything. Even if the person is very well trusted, they will not agree on this thing. It could happen, but then it goes to court. Then you have to go to court and ask for an appointment, which, like the speakers before me had said, it will take at least about 5 to 6 months for an appointment to happen in those scenarios. With a good judge, maybe 2 months. They will give one opportunity to the other side and then hear it and complete it. Any other questions, sir? Thank you. Yes.
For the domestic, generally with domestic, they will anyway have it within India, like Mumbai or
Yes.
With international,
Yeah.
does it generally go to the outside of India, or are the Indians having?
That's the thing, ma'am. So what we've seen in practice is typically, while they say that SIAC, Hong Kong International Arbitration Center, LCIA, they're all very popular venues. What happens most often is that corporations favor venues that are domestic to them. So if you have a European or a UK based company, for instance, more often than not, they will either opt for LCIA or for Paris as the arbitration center. Southeast Asian companies often opt for Singapore traditionally, now Hong Kong a little more. But sometimes what happens is that if there is, for example, if there is an Indian party and a London-based company or a European company, sometimes European companies, at least traditionally, they've been a little more distrustful of Indian-seated arbitrations, because they feel that, especially if it is with government entities, etc. So we've had a case where, as a sort of compromise, what had happened was that I think it was a large PSU here and a Japanese corporation. The Japanese didn't want to come to India, the Indians didn't want to go to Japan. So what they agreed on was Singapore as a via media solution. So that sort of thing can happen where they agree on a mutual jurisdiction which they think is trustworthy. But otherwise, if one party has more bargaining power, they generally try to keep it in their domestic institutional arbitration, because there's a little bit of a home ground advantage. If nothing else, even if the person is completely honest and the institution is completely unbiased, if nothing else, there is a cultural advantage, there is a language advantage that you have of being the local party. So typically parties prefer their own national institutions. Thank you.
Thank you, sir. Sir, the session was so, developments, and with the subject was, it shows how outstanding you are in the field, sir. Thank you, sir. Thank you for the session. Thank you, sir.